we should be good.
Okay. Good morning. This is the convening of the Massachusetts Gaming Commission. We are a few minutes off our mark today. We just completed an agenda setting meeting. Needed a few minutes for a quick break. We're holding this meeting virtually, so I'll take a roll call. Good morning again, Commissioner O'Brien.
Good morning again. I am here.
Good morning again, Commissioner Hill.
Hello, I'm here.
Good morning again, Commissioner Skinner.
Good morning, Madam Chair.
And good morning again, Commissioner Maynard.
Good morning, Madam Chair. I did not leave.
All right. So again, I thank the entire team for our agenda setting meeting. It was productive, and are looking ahead to March and into April as busy months. Shifting a little bit gears and even thinking about horse racing. So with that, I want to just add briefly an administrative update. It's not marked on our agenda, but it is certainly part of our tradition. So I want to turn to Executive Director Wells.
Yes, thank you very much, Madam Chair. Just a few updates with respect to the launch of sports wagering. We are still on target for a launch of March 10th. We have not publicly stated a time for the operators. I'm suggesting that we just go, if there's no objection from the commission, we give them a 10 a.m. start time so they can begin to plan for that. So is there any issues with that, or may I go ahead and just allow them to start at 10 a.m. should they get their operations certificate on the 9th? Does that sound good?
Commissioners?
Okay.
No objections.
Okay.
Excellent.
There's no objection, Madam Chair, but I do have a question that
Sure.
since this is
Thank
not a brick and mortar operation, why we would wait till 10 and not have it earlier?
I think it was just more that if there are any issues or any questions or anything going on around the start time, that we would have our staff on duty and working at that time should anything come up.
Excellent. Thank you.
Yes, to get organized. Okay.
Thank you, Madam Chair.
Thank you.
Well, thank you, Commissioner Hill. And just on that matter, I know that Mills will coordinate pushing that out publicly.
Yeah.
Karen,
And our team has been getting questions, so I know Crystal had flagged that, so we can respond and let them know directly.
excellent.
Okay. Second update, we do.
Karen,
Yes.
I'm sorry, I'm a little late chiming in, but in terms of commissioner schedules for the day, there's not much that we need to be prepared to be involved in on that day, right?
No.
Correct. It's very different from the launch on site because there's no actual location to go to inspect anything like that. So just a different animal in this kind of.
But to that point, Karen, Executive Director Wells, we just went over this. On the 9th, we'll be looking to issue the certificates of operation. So all that testing and all will have been done, Commissioner Skinner. So that's where we give the go ahead, and then they get to turn the switch on at 10 a.m. Eastern time.
Correct. Oh, Eastern Standard Time. That's a good point. I should make a note of that. Eastern Standard Time. Okay. The second update is with respect to the operations certificates. The plan for the 9th would be that we would only bring before you the operations certificates for those operators that are prepared to launch on the 10th. That allows GLI to focus their energy and efforts on the ones that are ready to launch. There's a couple that would not be ready to launch for several weeks after that. We would bring those operations certificates back in front of you at a later time. Just want to make sure you're clear on that process. That helps GLI, and I think it just helps streamline the process going forward. The third update, I just want to make you aware, given that the commission has done some tweaking and thinking about regs 254 on responsible gaming and 238, that does impact the review of the internal controls. So GLI had flagged that because when there's a change, they have to they're looking at the internal controls with respect to the change. So we're meeting with them this afternoon. We're going to come up with a solve for how to bring that approval in front of the commission. But I just wanted you to be aware that given that when regs change, that also changes the look that GLI is doing on the internal controls. So we'll be monitoring that. I can give more of an update. I don't know, Bruce, if you have more of an update because you spoke to Joe directly.
Yeah, it's just a couple little parts of it with the responsible gaming and the 10,000 part, no more than that $10,000 wager there. That part not being totally finalized, it's hard for them to put a stamp of approval on it, but we can pinpoint where we are prior to them approving the internal controls. So it's little bits like that they're having trouble finalizing in their internal control approval.
So we'll come up with sort of some more information at the meeting this afternoon, but it may be there's some sort of interim approval and then a final approval after the launch with respect to the newer version of the regulations in that short period of time, but more to come. I just did not want you to be not aware that does impact GLI's work. Okay, and then just the final update is other than that issue and that affecting the process a little bit, we've gotten very positive results from the testing and from the reviews of the internal controls. So we're not seeing any issues there, and that seems to be moving along well. So I'll have more information for you in the interim, but just wanted to make you aware of just all those issues that are coming before us.
With that, all the mobile prop companies that are moving forward, everybody seems on target for the March 10th at this point. So hopefully things keep going smoothly.
Excellent. Mina, I think that the issue that GLI is raising, am I right that today we're voting on those? So there will be some resolution today. However, I must reserve the commission's right to reevaluate. That's the beauty of regulations. We know that we need to have consistency for the operators and for our process, but I think we know that we're always going to continue to listen and evaluate and tweak, particularly at the beginning. And Bruce is nodding his head because it probably seems familiar to him, having opened so many casinos and now in this industry. So
I'm sorry,
we-
Karen, could
we
you just
appreciate
repeat
their
the
concern.
ones, the numbers?
254 and 238, and I was just briefed by Bruce this morning, so I'm still learning exactly what the what they have to do.
254.
254.
254. So that's the cooling off period, which we've had a lot
Got
of
it.
discussion.
Okay, got it. Yeah.
And then
Yeah.
the other one is
And 238, you said?
Yeah.
238. There's just little parts in that we've been discussing and haven't been finalized. So they were
Got
a
it.
little concerned because it's not final in certain parts as to how to approve it. I think we'll end up working it out, but they were a little concerned with giving a final blessing on something that hasn't been finalized. So
we're gonna resolve it today. But that one, if am I right, Caitlin, that has to do with the issue that came up around kiosks and the bet limit and having to go to the window versus the kiosk.
I don't actually know what the particular issue is, but that is something that could change.
yeah, the
Yeah, that's it. I
$10,000
got it
limit.
down. Yeah. That was that was the big discussion yesterday. All right. And the why we asked for input.
Exactly. So, all right. So many thanks to GLI. They really have been tremendous and tremendously efficient in this short period of time. So, and flagging these little issues so that we can resolve them before the launch is really, really helpful. So.
Yeah. No, and as I mentioned, the agenda setting, we are really grateful for everything they've done. And they were right there yesterday for us on that issue. So thank you. Commissioners, anything you want to add to or ask of Karen?
Yep, just wanted to make you aware of it, so.
That's good, Bruce. And commissioners, do you have anything you want to ask or add?
Just, Madam Chair, just kudos to the team and to everyone. I know that it's been a real slog and everyone at GLI, and I think that it's, really going to be a benefit to the Commonwealth that, before one of the largest sporting events in the country, March Madness, that it looks like everything's going to launch. And so thank you, Karen. Thank you, team.
Thank you.
So let's make it happen and turn to regulations, right?
Sounds good.
Um,
Okay.
Okay, so I think the best way is to kind of set the stage from yesterday. There were some outstanding issues. There were regs that we hadn't looked at yesterday because they came in yesterday. I think we decided we would go back and then move forward with the new stuff. Right, Mina?
Correct, yeah. And Carrie and Caitlin and Todd, I don't know if you have any prefacing remarks. If not, I can launch right into 138 and 238.
I just wanted to mention that in terms of the packet, it looks like the version attached to the meeting invite is yesterday's packet. So I did circulate the updated packet to you just a couple of hours ago. So we'll have the same page numbers we're looking at.
Carrie, is the right packet online for members of the public to access?
I don't think anything is online yet, the last time I looked.
Well, right now, Trudy is without a laptop, so that's impacting her ability to be nimble. I have a 246-page document. Is that the most up-to-date one?
It's about 300.
It's
301 is the one I've got.
All right. So, of course, I was in transit last night. So, if somebody could send.
I sent it this morning, Kathy, at 9:57 to you, if that is helpful.
Oh, I wasn't looking at emails at.
Oh, no, of course not.
9:57. I was getting ready for the other meeting. Okay, so.
Madam Chair, I could, if it's helpful, for at least these two, there's only a handful of comments we're going to talk about. I could do a screen share as we're talking, which might also help with the public viewing of it. I know it reduces ability to see everybody's faces, but.
Well, yeah, it does, but I just need to get this onto, I need to find it, Mina, so just bear with me.
Sure.
It came from Carrie, right? Got it.
Yes. Yep.
Okay.
Chair, if a member of the legal team will shoot me the latest version, that should be going up on the website. I'm happy to get that up there.
That'd be great.
Just sent
Thank
it
you
over
so
right
much,
now.
Alice.
Thanks, Carrie.
Okay. There we go. Takes a village, guys. Thank you so much. Did it start with 205, 138?
Correct. Yep.
Okay. I'm just using my other device. That's why it's a little bit slow, guys. Sorry. Now I can even read it. There we go. Thank you for that. So where are we starting?
All right, Madam Chair, let me both in light of Karen's comment and Bruce's and your intro, just reorient everybody to where we were as of yesterday on this one. As you might recall, 138, we had not received any comments prior to late, I guess, Monday night, early yesterday. So there weren't any. So there weren't many comments to talk about. We then received two comments, one about 13805 regarding the issue of suspension or termination of an employee by an operator when they're suspended or terminated by by the Bureau or the Commission, and the data security protocols in 13873. We talked quite a bit about 105 yesterday, but not about 73. So I'm going to walk through both of those. At the outset, we also had one small thing, which I apologize, did not get picked up in the change. So on page 1 of your packet, the red line there for gaming will actually come out. So we'll just read uniform standards of accounting procedures and internal controls, reflecting the fact that this is for both gaming and sports wagering. So I apologize for that error, but that's a small fix. Also, just as a reminder, the red lines in this particular document have to do, because they're red lines on an existing regulation that's been in place, they're not necessarily new as of even before yesterday or of yesterday. We did try to highlight where we have changes or changes to discuss. So the first substantive comment is, or first just point for discussion, is 13805, which is down at page 10. Based on the comments we got, this is 13805D. We had received a comment yesterday from DraftKings suggesting the language that you see highlighted in yellow here be added, which is procedures that internal controls need to include procedures for terminating or suspending, or modifying the relevant responsibilities of the employment of individuals licensed or registered, et cetera, if the commission provides notice that the registration or license has been revoked, suspended, or denied. We, pursuant to our conversation yesterday, followed up with the IEB on this point and whether they had concerns with that particular change. And they did say that they do have concerns with that change and would recommend against it. A couple of things. One, this has not been an issue with gaming operators. This was in the gaming regs before. I think the concern, to boil it down, has to do really with the vagueness of what exactly the modification of relevant responsibilities might be, and that it might lead to sort of an when access needs to be cut off at a particular moment, it may make it inefficient or difficult to know if somebody is truly out of a network or has met their responsibility to do that. The fact that there is a procedure for suspension, not just termination, it was also something that came up, that there's no suggestion here that employment needs to be taken away, or that pay needs to be taken away. It's simply that the person is suspended from the duties here. So while in practice, this may mean that someone's assigned to a different portion of a company or something else, and that may be okay in a particular circumstance, they would prefer the language stay as it has in the past and not adopt this change.
Question for Mina on that, Commissioners? Okay.
So just to be clear, because we put the language here so that everyone could see it, what we are proposing would be not to include the highlighted language on page 10. The only other set of changes that would come up for 138, 205, 138 are at the very end of the reg. So I'm going to be scrolling for a little bit here to page, this is in the 90s. Nope, actually a little before that. So we had received several comments from two different entities about the new 13873. When this is a new addition altogether to the internal controls regs that would apply to gaming and sports wagering entities. The nature of the comments ranged from a request to remove this altogether and simply rely on background data privacy laws. There were suggestions. One commenter noted that Massachusetts cybersecurity laws are still themselves in flux. There was also concerns in the comments raised about particular details of this. The legal team met yesterday afternoon to talk about what might be the best approach. We wanted to strike a balance in our recommendation is to strike a balance between making sure that there's adequate data security for patron information, but also not getting into an overly prescriptive set of requirements that may not make sense in the particular context without having had adequate time to review the comments and really talk to the operators who made them and make sure we understand what would work instead. So our suggestion is to leave 138.73, 1 and 2 effectively as is with one small change that I'll mention, and strike the rest. What that does is 138.73.1 sets out the basic standard that, which is actually captured in other regs as well, that personally identifiable information needs to be protected at least at the level that is required under state law, under Chapter 93H and 201 CMR 17. And 2 requires a system of internal controls that does that. The remaining provisions have to do with details such as patron access to their information, the use for of aggregated or anonymized, data, and other and sort of the destruction of data when necessary. All of which could still be in someone's data security plan, and all of which we think would be appropriate to address perhaps in a separate reg. But seeing as this not only affects sports wagering and gaming, we did not want to, we want to take seriously the comments that were made and not delay the passage of this reg with the key provisions, but take a closer look at some of those other provisions in 3 through 8. I will say there were really no comments on 1 and 2, other than questions about 1, whether personally identifiable information means the same thing as it does under state law. The answer is yes, it does, but we made that even clearer. You'll see in sort of maroon font here in 138.73.1, as defined in Chapter 93H and 201 CMR 17, to just make it absolutely clear that we're talking about the same thing. So we would propose coming back with revisions either to this reg or a separate reg with more detail and in the near future, but for the purposes of internal controls at the moment, having a broader requirement that's less prescriptive.
Commissioner O'Brien?
So, I did want to bring up for this group, but also for the legal team in particular, I recently had conversations with Jared Reinheimer, who's the head of the AG's Data Privacy and Security Division, and he had questions for me about the apps, the mobile protection, et cetera. So if there's a way for your team to reach out to them as well, because I think their expertise and their thoughts on this would be helpful for everybody.
Absolutely. If there's a, we in the legal team can talk about the best way to do that. But between them and GLI, I think it would be worthwhile to have that conversation. Commissioner O'Brien.
Yeah, I know, because they're, like I said, they're particularly interested. I know they've reached out to at least one licensee to get a better sense of sort of the interface with the app and that sort of thing. So thank you.
Anything else, commissioners? Any objections to this being struck? Then we'll revisit. Okay, let's continue.
Madam Chair, that's it for 138. So in just to reiterate that the one change or substantive change would be the striking in 138.73. of everything after 138.73.3 and forward. The change to the title of the reg to take out the words for gaming. And then no change to 138.05 D, other than there's a small typographical correction. And we would not include the highlighted language in 138.05 D. So this one should be ready for a vote.
And in terms of looking at the new regs, they're in the packet.
Correct. So it's the pages 1 through where I just was, which I lost, sorry, 138 ends on page 79.
80, oh, I have 82 at the beginning of the.
Correct. I'm sorry. The last 2 pages are the auto-generated document compare. That's why I didn't count that, but that's right.
Yeah, that's fine. And then 82 starts the regs. And it looks like you've addressed all of the new ones that came in here.
Correct. These were all new comments. There were no 138.05 was the first comment. The rest were about 73. And as you'll see, there was comments to remove the whole thing. And then a couple of questions about clarification. We didn't talk about these one by one yesterday, but there were a couple of questions about clarification. All the rest, starting on page 87 of your packet, you'll see have to do with 138.73 or subsequent sections, and those would be removed for the time being.
So Mr. Miller's the questions are no longer.
Except with respect to number 1. And to clarify, I can answer those right now if it's helpful.
Yeah.
I had already answered number 1. The definition of personally identifiable information is the same as under state law. That is clarified in the change we made in today's packet. Regardless of he had a question about, we are unclear about the intent of the words regardless of residency. I'm not exactly sure what he's getting at there, because if you are doing business in Massachusetts, you have to comply with data security laws in Massachusetts. And that's, so whether or not someone's a New Hampshire resident betting in Massachusetts, they would still have to have their data protected is the issue there. The gaming licensee, that's the questions about, is it only sports wagering that occurs in a physical sports book? At what activity is subject to regulation? I guess I'll just take it broadly. This one would apply to gaming and sports wagering. So everything. And then the last question, does the regulation cover every non-gaming activity that occurs anywhere inside a gaming licensee's property? The short answer to that is probably not. I mean, these are ultimately internal controls for the gaming establishment and the sports wagering facility. However, for instance, uses the example as a dining reservation or the purchase of a t-shirt in a shop. Typically what will be collected for that might be credit card data. And again, under state law, they would have to protect that data if it has personally identifiable information or bank account information.
Okay. Any questions on those? All right. So we're going to move on then to the next reg.
We can do that.
Or should we, Caitlin, how do you want to do this? Should we act maybe on this now?
So, Madam Chair, can I just ask one question before we move on, acting on it or not? And just a question for the team, both the attorneys and then people on the technical side is, are you comfortable with the recommended deletions in terms of addressing privacy protections that are required under the statute?
The legal team is Commissioner O'Brien. We had that discussion.
Bruce or anybody with GLI can answer the technical part of it.
Oh, Joe's jumping on now. I was going to say I talked to Joe briefly this morning, but Joe, go ahead.
Yes, we talked this morning, and we are in alignment with the recommendation from the legal department.
Okay, thank you.
Okay.
Madam Chair, we have historically done these separate. And
I think we should, while it's fresh in our mind, Commissioner Hill, I would welcome a motion.
Well, then, with that said, Madam Chair, I move that the commission approve the amended small business impact statement in the draft of 205 CMR 138 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Thank you. Any questions or edits on that motion? Commissioner O'Brien, that was an important question to ask before we went into this, so thank you.
Well, knowing that we're coming back to revisit it made me a little more comfortable.
I think that's right? Okay. I'll ask Karen to keep track of that for us in addition to the legal team. So with that, we'll have Commissioner O'Brien. Turn to Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. 5-0. So we're all set. Move forward 205 CMR 138 GLI. Check on that one. There we go. Now we'll move to, we're going back to 238, correct, Nina?
Correct.
Okay, and that's on you, right?
Yes. So no, there were no additional comments beyond the ones we discussed yesterday. The only additional comment received that was not originally in yesterday's packet, we did address yesterday. So I won't go back through comments. I will just outline, and there were no really open issues. So this is just a review of the discussions we had yesterday for finalizing this. The first change, this starts on page 100 of the packet. The first change is the inclusion of the word additional at the outset of the reg for the name of this one, which I think was Commissioner Skinner's suggestion to make this clearer, that this is for additional requirements for sports wagering. And then the next change, there are a couple of changes. I can go through some of the other changes we discussed and where everybody was okay with yesterday. If it's helpful just to reorient folks, is that
think so.
238. This one is another long one. 238.18, starting on page 16, and really the changes start on the bottom of page 17.
Is it starting on page?
I'm sorry, 115 and 116. I apologize.
Thank you so much.
The bottom of the page number.
Thank you so much.
No problem. These changes were the ones requested having to do with sharing of information with the sports governing bodies, and I think we discussed all of these. All of these were okay yesterday, but the changes on pages 115, 116, and 17 all are in that vein. Some of them do come, and we talked about the comments that led to those yesterday. So no new changes there. The next set of changes comes on, just want to make sure I don't miss any. 238.32, which is at page 127. This was similar. I think if you recall, we broadened and aligned the term subcontractor qualifier to match up with other regs. This is also the requirement that an employee of a sports wagering operator, for example, cannot place a wager not just on their category 1 licensee, but also on the tethered app was the purpose of this. And of course, a category 2, but just thinking of what's in place today. The following set of changes, page 129, in addition, a reference to 205 CMR 152, which I think was not, we didn't have much discussion on that yesterday, but I think everyone was okay with that. Now on page 130 is the first thing that we talked about yesterday, but is not in the packet. There's a very small but meaningful change in 238.35, removing the word only to clarify that the list of reasons for canceling a placed wager are mandatory in 1 A through K on the following page. The next change is on page 133. This is the kiosk discussion. And so this just reflects, just to kind of reiterate the conversation, the question was whether or not to allow the placement of a wager at a kiosk that may result in a payout of $10,000 or more. The collection of that payout and actually cashing out the payout would still happen at the ticket window. To recap the discussion yesterday, the original concern here was anonymity and potentially somebody not trying to evade tax or other obligations. However, as was clarified during yesterday's conversation, this is actually no different in terms of the anonymity at the ticket window when the wager is placed. The requirements for information happen at the back end when the payout is made. So deleting this language would allow a wager to be placed at a kiosk that could result in a greater than $10,000 payout, but would not allow, because of item A, and just simply the process that's in place for how payouts are made, you would still have to go at the window to actually get your money. So I don't know if there's...
Commissioners, do you see now with the struck language, that's pretty clear? There is one outstanding issue that I think Sterl raised. Under 2A, they're prohibited from issuing or redeeming the key at the kiosk, sports wagering voucher with a value in excess of $10,000. But yesterday, the number 5,000 came up with respect to tax implications. Is that number right? Should it be 10 or should it be 5? Commissioner O'Brien, were you thinking of the same issue? Or?
I was thinking of the same issue in terms of A, what that number should be, and then B, something for us to put on the reg review running list is the concept that to be more aggressive in compliance with delinquent child support and track tax implications is, do we want to discuss putting more protections in so there's no anonymity to the bets that could trigger that requirement? But in the short term, yeah, my question has to do with the dollar amount on this reg.
Yeah, so I think we've got it on the reg, whether we develop those additional, I think we'd love to see some, we'd love to see some technical evolution for the kiosks. So I'll go back to the legal team. Have you explored the amount, Caitlin?
So there are a couple, there's a statute that says that if a payout is going to be $5,000, if it's $5,000 and the terms of the payout were at least 300 to 1, it has to go through the intercept process. And so we could absolutely consider incorporating that. I haven't thought it all the way through, but we can consider incorporating that in this to make sure we're capturing that as well. Although it already is a statute, it's already being done. We've looked into that piece of it.
Oh.
I actually
the 300 to 1 is familiar, but where was it? It's somewhere in a reg. Was it in a different reg?
It's in chapter 23N, but you have to look at the Internal Revenue Code to get the $5,000 piece. That's why it's complicated. But it seems to me, and the reason I hadn't said anything is because I think it's captured in paragraph B, where it talks about limits set by the IRS. And that's, I mean, I assume that was referencing the intercept amount.
Well, let's be clear.
Creating confusion by not specifying.
So we could say, we could actually, it's chapter, I'm sorry, it's chapter 23N section. It's the last section. I can't quite get. My internet's not working at the moment, but it's, we could put in the specific section in 23N that talks about the intercept. So you basically, the $10,000 is the money laundering threshold. And then the other issue is the $5,000 at 300 to 1, which is the tax withholding / intercept threshold. So those are, I think, the two thresholds that you're concerned with that you want to reference here.
So this is critical for GLI, right? am I right that GLI is already planning on the 5,000 with 300 to 1? Because they already have that because it's a statutory provision. There you are, Joe. Good morning.
Good
Oh,
morning.
good afternoon. Good afternoon.
No, morning. Go ahead.
Yeah, good morning. Been there. Yeah. Good morning.
Yeah. No, I'm in Southern California, so.
Yeah, I was just there yesterday, so that's.
Oh,
what I
okay.
mean. Been there.
Okay. So the reference is to the, as Todd alluded to, the stipulation by the IRS. Both things need to be true. 300 to 1, Caitlin, as Caitlin mentioned, and I believe the IRS is the 5,000 mark, right, Caitlin?
Correct.
And this is standard throughout the industry how it's triggered because of that qualification on the federal level.
So to Commissioner O'Brien's point, should our reg reflect that? With the understanding the IRS could change the threshold amount at any time? Could we? Commissioner O'Brien?
Yeah, so now that I'm looking at A and B, I'm a little confused. Why are we reiterating the 10? I'm just wondering if we need to be more specific. If it's the 5K and 300 to 1 consistent with the IRS code, and then the 10K is the AML SARS, should you have those listed separately? Stroll's got his hand up. I don't know.
Yes, 10,000 is correct, Eileen. You are correct. 10,000 is, and it is exactly 10,000, and then it's actually, the wording is over, so a penny.
Right.
So
That's where that's where the CTRs and the SARs are going to kick in, right?
Exactly. That's
Right.
that's for the CTR reporting.
Right.
So to write the reg perfectly, do we include
you say
both, or
5?
do we do the lower threshold and include IRS requirements? What do you think?
Can I have another-
We need to do both because it's
Yeah.
not just a 5,000. Sorry.
It's a 5 and a 300 to 1, or in
That's
the
right.
other circumstance is the 10K or up.
That's what I think too. So Caitlin, because we will be voting on this, it would be nice if we have some degree of certainty around the language.
Right.
Give or take.
I think there's another wrinkle. Am I correct in understanding that the threshold amount for DOR child support purposes is $1,200?
It's just for
I
slot
heard
machines.
that this morning.
Slot
That's for
machines.
slot machines, so that's not this.
Okay, and so this is not applicable to sports wagering because the commission hasn't made it applicable to sports wagering. Is that right?
Not exactly. So there's federal law that talks about when you have essentially an event that requires either tax reporting or withholding. Massachusetts has tethered the intercept for tax and child support checks to that
Federal
threshold.
withholding.
So that once the casinos or operators are checking anyway, Massachusetts has said, you also have to check this. So if you look at 23N section, it's like 18 or what have you, it references the Internal Revenue Code. And it says, when that happens, you also have to do this.
Okay.
So that's where the $5,000 and 300 to 1 comes into play. But it is important to remember, Caitlin just said this, but it's important to remember, it's not either $5,000 or 300 to 1, it has to be both.
Yeah, we got, yeah.
And that's why you need the 10,000 on the one hand and then the intercept, the tax level on the other.
Okay,
Yeah, but the question is, should it be 5? I guess that's
Rather
what
than
I'm
10.
rather than the 10 when you're relating to the IRS code, because it appears to be a 5 and a 300 to 1, not a 10. That's what I'm confused about.
Well,
Yeah, I think. Oh, sorry, Joe.
I'm just going to reiterate that, like, you could bet $9,999 and win 10,000 and a penny, and that would trigger the $10,000. I'm fading the legal term. I haven't had enough coffee. AML at the IRS
CTR.
level. Thank you. And the $5,000 and 300 to 1 is a separate. They're two
Right.
separate.
Right, I think we understand.
that's
that
the
those
point-
are
that's
two
the point I'm
separate. Now,
making.
one second, Commissioner O'Brien. I'm going to turn to Mina, because I know that Mina's hearing this. We need probably some fixing on A and B. What would be your recommendation, Mina? Do you have it?
So I think there's two questions. One is a policy question of whether you want to just lower the 10,000 to 5,000 to capture more of these or not. But, so that's just one question. But let me just finish on the second.
I don't think we're here. I don't think we're saying that. I think we understand it's 5,000 plus the 300 to 1. And then we understand it's the 10,000. So we
Okay.
probably need two provisions. It's probably B is
so
it's messy because it says in excess of 10,000, it looks redundant rather than 5,000.
I would not change the or in excess of limits set by the IRS. They
No.
are right. They are
That's
5,000
right.
because they are particular today, but we don't know where they are any given day. So I would leave that language as is. What it says now is issue or redeem a sports wagering voucher with a value in excess of 10,000 or issue a payout in excess of 10,000. A very simple fix to all of this, I think just to propose would be to have it all in one place to say issue or redeem a sports wagering, or redeem a sports wagering voucher or payout with a value in excess of $10,000 as A, and for B, issue a payout in excess of limits set by the IRS, simply to have one be the IRS limit and one be the 10,000. So you can separate out the two.
And that's so that the IRS can change and whatever the current situation is we're meeting.
Exactly.
And that's the 300. But the 300 to 1 is our statute.
That's the IRS code, right?
Yeah, that's the Internal Revenue Code, which is made applicable by our statute.
Oh, it doesn't actually say the 300 to
No,
1. I haven't looked at that provision. Okay,
Yeah.
fine. We're good then.
Yeah.
I
So
think-
can I ask to Commissioner Skinner's point, can you just give me a little more clarity on, Todd, where the commission stands in terms of what's the line we have drawn in terms of capturing child support? I'm just trying to understand, is that something that's another policy question that's in front of us or could be in front of us? Or, because it seems like we have the potential to capture that as well in a different threshold than what we're talking about in A and B.
No,
If we chose to do it.
yeah, I think that, again, unfortunately, my internet's not working, so I can't pull up the exact language here. If someone can find it, it's the last section of 23N. That the statute sets the threshold for us. So I don't think you need to move it at all. It's kind of the well-settled level at which they have to issue a W-2G anyway under federal law for anyone who hits that threshold. So it's a convenient time to also run a query as to whether the person owes taxes or child support. If you were to reduce it, it would result in more queries, I believe.
And I'm sorry, what's the threshold that again? Is it the 10?
No, it's 5,300 to 1.
Okay, so it's the IRS.
Yeah, so the 10,000 is totally different. That's the
That's the AML.
that's the
AML.
fencing and anti-money laundering.
So I guess what we're not seeing are the words child support or taxes, but what you're saying is that with the revised B, that's going to get them to the window where they will be looked at for the child support as well as tax liability, Commissioner Skinner and Commissioner O'Brien. Does that
And then
work?
is there a reg
I understand.
that cross-references that in? Can you,
Say again.
and if you don't have the site in front of you, Todd, that's fine. I'm just curious what our reg is that then make sure that's triggered and make sure we're not missing anything in terms of making it applicable to a sports wagering payout.
Yeah, I don't have it right in front of me. I do recall seeing that we do have a reg that requires, I want to say it might be in 138, where they have intercept procedures in place. That's also, of course, governed by the MOUs that we'll be negotiating separately, but I do think we cover it somewhere.
138.56.
56, thank you. Let's see if we can find that here.
Can somebody read that to us, please?
It's an IC requirement that they list their procedures for running intercepts.
So that's on page
It's page 67 of our packet from today.
67.
I'm reluctant to scroll. 67, no, I've got it. My number changing is not very nimble here. There we go. 67. Yeah. It's
Okay, so
56.
this makes repeated references to slots, but you're telling me that the language incorporates this payout venue as well.
Actually, Commissioner O'Brien, that is specific to gaming licensees. It's 238.
238.56.
No, 238.15 and 238.16.
And what number is that? What page is
And
that?
what page is that in our packet?
I'm getting there. Oh, page 114.
114.
Thank you.
Okay.
This is where we put so 238.15, which has not changed today, is compliance for all tax withholding, ensure compliance with IRS requirements.
But it doesn't mention child support, which is different than
No.
taxation.
So
Is that a withholding required by DOR in sub 1?
I don't believe the words child support appear in the gaming side either, right, Sterl?
So it appears in the statute in the last section that child support, and then it references the code number by the federal government for taxes, which I have on my screen if you want me to share. That Todd was
I guess-
looking for, but it says, in general, except as provided in subparagraphs B and C, proceeds of more than 5,000 from a wagering transaction, if the amount of such proceeds is at least 300 times as large as the amount wagered.
Yeah.
And that's for all,
And in
the
our
B and C
statute,
is for lotteries and then sweepstakes.
and then in the statute, child support is in the last provision of 23N, Sterl?
Yes,
So it's
that, so
referenced there.
that, in the statute, it's in section A of 24. It states prior to an operator's disbursement of a cash or a prize that is subject to withholding under the section I just read, section 3402 of Internal Revenue, the operator shall review information made available by the 4D agency as set forth in Chapter 119A and by the Department of Revenue to determine if a winner of a cash or prize owes any past due child support to the Commonwealth or to an individual to whom the 4D agency is providing services, or to tax liability to the Commonwealth.
So it's the same 300 to 1 trigger.
Yes.
Correct.
Yeah, and just to reiterate, the portion of 238.36 that we're talking about, which is on page 133, this just has to do with what a kiosk can do without going to the window. So this is, it does capture all of that, but is really just an additional check on it as opposed to what happens at the window.
So Mina, eliminating B there would allow a kiosk to accept an anonymous sports wager with a potential payout in excess of $10,000. And that's okay from a policy perspective because operators, retail operators require the patron to claim their winnings at a window. Do I have that right?
Correct, Commissioner Skinner, and as does
rest of the reg,
section, yes, as does subsection A and what used to be subsection C, which will now be B.
Okay.
So
Yeah, so what happens if we keep being Commissioner Skinner, then you can't place that a $3 bet if it's going to result in something over 10,000 at the kiosk. So you'd have to place it at the window, which might make sense if there were additional identifiers, taking care of the anonymity, but there really isn't at the window.
Right. And that's to me, maybe for something down the road, if there's a way to, I think about you go skiing and they go, "Here, I'm taking your picture now. So when I check you later, I make sure this is really you on the card." If there's something later on technologically that a kiosk or window allows you to make it not anonymous, that's great.
But they can't get their winnings no matter
They can't get the payout without the check.
They can't get it if it goes over 10 grand. Yeah. So that's why it makes, otherwise the individual gets to the kiosk line, gets in there, places decides, I want to place a bet and sees it's going to trigger over 10,000. They have to step out and go to a new line.
Got it.
Yeah.
Nina, I'm going to nitpick for a second here.
Mhm.
Can we change issue to issuance and redeem to redemption, just so that's
that's fine.
grammatically correct?
I am happy with that nitpicking. In that case, that makes sense. So, Madam Chair, may I just read A and
Yes.
new B one more time? And I think so. This would read the sports wager. I'll just read all of 2. The sports wagering operator shall ensure sports wagering kiosks are configured to prohibit the following: issuance or redemption of a sports wagering voucher or payout with a value in excess of $10,000, semicolon. B, issuance or redemption of a sports wagering voucher or payout in excess of limits set by the IRS, period.
Everyone okay with that?
Could you just read B for me again, Mina? I'm sorry.
Sure. Issuance or redemption of a sports wagering voucher or payout in excess of limits set by the IRS.
Okay.
So they would be parallel except for the last part.
Because the IRS limits could be changing as we speak.
Yes. And I should just say, and there'll be an and in between the two.
I was going to ask, is it an and or an or?
Yeah.
Okay, good. That's really helpful. And that's important for GLI, Karen, for today. We understand. How's the team feeling about that? Legal and the sports division. Thank you, Sterl, for all your input. Okay. Okay, Sterl.
As long as you guys are good.
Thank you, Sterl. All right. Should we continue?
Sure, Madam Chair, that's actually it for 238. So
I thought so.
Yeah.
Yeah, that was my notes too.
Do you want me to briefly review the changes for today, or are we set?
The changes that we just went through?
Just went through, yeah.
Commissioners, there were only a couple. Are you okay with the ones that he went through? You
All
need
set.
him to- I'm all set too. Commissioner Skinner, you all set? Commissioner O'Brien's nodding her head. Commissioner Maynard, okay. No, I think we're good, Mina.
It's great,
We've
thank
been
you.
Taking notes along the way. Okay. So that brings us to the end of that packet. Of that reg is what page?
The end of that reg is on page 139. The comments
Yeah,
follow. We
okay.
talked about all the comments yesterday, so there's no new comments.
No new comments. So there we go. So with that, commissioners, and that was a really important conversation to have. We resolved it with a little bit of rest. Do I have a motion on that one?
Madam Chair, I move that the commission approve the amended small business impact statement and the draft of 205 CMR 238 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Any edits, questions? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. There. Thank you to GLI. I know that that was a tricky discussion yesterday for them, so thank you. All right, Nina or Caitlin or Carrie or Todd.
Madam
Carrie.
Chair, if it's all right, if we could take 254 next, a little bit out of order, just to accommodate Attorney Mackey's schedule today.
Oh, he's back. Good afternoon, Attorney Mackey. Yes, we're looking at 254 temporary prohibition. So the from sports
That
wagering
begins
cooling off.
on page 211 of your packet.
Thank you.
And as I understand it, what the agenda is for now is to go through the new public comments that we didn't have an opportunity to review yesterday, just to have a brief discussion about those to see if there's any further edits that we'd want to make to the cooling off reg. So we've reviewed the new public comments carefully. I think those start on 215 of the packet, if I'm not mistaken.
That's right.
And there are 5 comments that we didn't have in time for the meeting yesterday, 3 of which have been already addressed and 2 of which might deserve some discussion. So the first is comment to 254.023, comment from DraftKings that an acknowledgement by the patron isn't necessary here with respect to the things that they would not be able to do during a temporary cooling off period, that an acknowledgement shouldn't be necessary, and that it just be, notification to the patron of the things they'd be unable to do during the cooling off period. I think the general consensus, having talked it through with Mark and others, that an acknowledgement by the patron is a significant step, and the patron's more likely to understand things that they'd be unable to do during the cooling off period if not only do they see the conspicuous notification, but also acknowledge the contents of the notification. So I don't think that we're recommending we make a change based on that comment. Then the second comment on 254.031 suggests this comment from FanDuel suggesting that we be more flexible about the specific timeframes we're allowing for the cooling off period, and we've addressed that. This was we'd initially had 72 hours a week, 2 weeks, 3 weeks, or 4 weeks, and now we're making that time frame flexible. So then the next comment, also from DraftKings, is that the cooling off period, that the patron should not be able to extend the cooling off period during the cooling off period time frame, but only at the conclusion of the cooling off time frame. I think the view from Mark is that no, a patron should be allowed to extend a cooling off period, and really take advantage of any of the responsible gaming tools at any time, and shouldn't simply be restricted to extending it once the cooling off period is ended.
Can I ask the question? Did we explore that with GLI to see is there a technical issue there, or is that why?
I'm not aware of that. That we did. I think the consensus on that was simply that we want to make these play management type tools, responsible gaming tools, available to patrons.
Absolutely.
They have the desire to take advantage of them.
Yeah, so I'm not questioning the underlying policy, because that's very clear to me, Dave. I'm just wondering, are we unique in expecting that? Because I'm just wondering why they raised that. Joe, do you know?
The uniqueness question I'd have to research to give a definitive answer.
Do you understand the issue? That, in other words, does if you're a patron, do you have to wait for your 72-hour to conclude in order to technically be able to extend a cooling off period? Is most apps built that way? Reason why we're wondering, Dave, we don't want to have a compliance issue on, sort of unintentionally for March 10th, although we may want to, depending on how the commission thinks about this issue today.
So what the comment specifically says, Madam Chair, is that allowing renewal during the cooling off period would require that an individual access the account, which would violate 205 CMR 25504,
Right.
25402. But we've now amended that piece so that you can access your account during the cooling off period specifically to engage in these responsible gaming tools or to withdraw your money. So it no longer would be a violation of the cooling off period for you to access your account to extend a cooling off period. So we've resolved that. The second piece of this, I'm sorry, but I can't add much value here, is they say it would require customer experience teams to manually manage an individual self-imposed limits. And it doesn't sound like they're saying that it would be impossible. It just sounds like they're saying it would be.
So we've eliminated the prohibition, and that prohibition isn't unique. That was unique to the industry. So in other words, the patron can always access their account and change. I guess I just want to know that a patron can always change their self-imposed limit.
We have addressed that in 254.02.1, where we describe what the temporary prohibition is. You can't place wagers on your sports. You can't make deposits into your account. You can't place wagers on the platform, but you can do other things with respect to your account. For example, withdrawing funds that are there, or taking advantage of these other responsible gaming tools.
I'm just going to turn to GLI. I'm not disagreeing with anything Mr. Mackey said. I just wondered, is there any tech issue that you're thinking of or is this is just nothing we have to worry about?
In regards to the functionality, there's most certainly a development or change window that would have to occur if these regulations required such a change.
Okay, so just to make sure I got the change right, I had chosen 1 week cooling off period, and as I near that 1 week, but I haven't completed that 1 week, I decided I want to extend it to 4 weeks. That right now isn't the technical norm, because you sort of have to wait for that conclusion of the 1 week, then to extend it to another 4 weeks or another 3 weeks.
As for the norm, again, I'd have to research that to come back. I don't have my living library, Mike Robbins, available at this time. He's on vacation.
Your living library.
But from my extensive experience in application management on the digital side, I would imagine that that exact functionality is most likely not available immediately and would require a technical change.
Okay, so can I make a suggestion, Dave? Can we pause on this, and Karen and team, can you try to figure out if this is a tech issue that we would need to give some relief? Because I think Mark would say, and I think that's what Dave is saying, it's a good policy. You may not suspend it forever. We want it, but do we give relief for launch if it's a real tech issue? Okay, I've done enough talking. Commissioners, what are you thinking? Are you in agreement with me, or do you not care, disagree, whatever? Because
I'm trying to get a handle on this. Sorry, I was looking, are they the only ones who've raised this issue?
yeah, that's a good
Yes,
question.
this is the only comment we got on this issue. And it doesn't appear
But
they're
none of the
saying
other
that they
operators
can't
are
do it.
saying this is a problem. So I guess I'm wondering why they're the only one that says this is an issue.
I don't read DraftKings comment as, it is from DraftKings, right?
Yes, that's right.
I don't read it as, that they're seeing a technological problem with it. It's just that they're saying it would require the patron to access their account, which is not prohibited under our regs. They just can't place a wager. So I don't see an issue there. The other piece of it, if the patron isn't accessing their account, it sounds like DraftKings is saying that a member of their team would have to manage that extension on behalf of the patron. So either one of those options, it sounds like, is doable for DraftKings at least. So I'm not hearing that there's a technological problem. And so I would just as soon leave the language as is. Unless, there's
that's kind of how I was taking it too, but
unless there's some additional
I was missing
information.
something.
Unless there's additional
I'll say
information.
the reason why I raised it was because I just want to make sure there isn't one. I think you're quite right, Commissioner Skinner. I'm not seeing that. I just want to make sure, because we've learned kind of after the fact a few times that it's more technically a technical challenge that they might not be able to switch. But I agree with you in terms of how you're interpreting the language. So that's why I'm just hoping it's like no. I was hoping for a quick no answer.
I'd like to add that, like, I could get a definitive answer. My answer is obviously not definitive. If you give me a little bit of time, and I can find out. But I will note that if they are the only operator that has made a comment at this, that is certainly a note to take forward. Because if it was universal, you'd hear all about it, like some of the others.
I'd like the clarity. I'd like the clarity as quickly as possible, and I'm crossing my fingers. It's just a no.
Okay.
But if it's something else, that would be helpful for us to know. The reason why I'm sort of not so stuck on the fact that only DraftKings responded is because we are working on this reg in real time, and they may have been the ones who just got to it. So I'd like to cross it off the list if it's possible. Thanks, Joe. He's going to work. All right. So otherwise, commissioners, you have no concern about the recommendation.
No, Madam Chair.
Thank you. Okay. Then we go on, Dave, to the next, and we'll just see if Joe circles back.
Just two more comments, but I think both have been addressed. One from DraftKings, one from FanDuel. Again, this relates to the notification provision that says as you approach the end of the cooling off period, you get a notification that you're approaching the end. They, for the reasons that have been discussed, think that that could actually, create sort of anticipation and excitement about being able to engage in sports wagering again, and it's not a good idea. So I think the decision was we'd remove the notification provision, obviously subject to the round table on the issue that Mark was describing yesterday.
Any questions? Okay, and then the next. FanDuel.
And I think that's it. As I say, 5 comments, 2 new issues, and 3 that had been addressed during the discussion yesterday.
Okay.
There is also a letter from FanDuel in here that addresses the notification and duration issues, which again we've amended the regulation to eliminate those requirements.
Any questions for Carrie on that? Carrie, we just have the comment on that, and not the letter, just is that the body of the letter?
It's on page 219 of your packet.
Oh, thank you. Let's scroll down. Okay. Dave, are you all set then?
I think so. I think so. I guess on the one issue, I just suggest this one point about the ability to extend the cooling off period in the midst of the cooling off period. As I read the comment, and I know this may be worth further discussion. As I read their comment, I think their concern about extending the cooling off period during the cooling off period related to the previous version of the regulation that prohibited somebody from accessing the account during the cooling off period, and that the changes that we discussed yesterday to that, where you still can access the account for certain purposes, may have addressed this concern of DraftKings. It's the comment
I agree with that, Dave.
about whether it's a technical or
an
issue,
yeah.
but it might just
I
be based
understand
on
that. And I do think, as I'm thinking about the assessments, the commissioners help me out. When they talked about extending, you could never go backwards, of course. I remember that discussion. But could you extend by having to go through their team to extend? Do you remember that as we had the demonstrations? They of course never wanted you to go backwards, and you couldn't, or maybe you had to do something special if you wanted to reduce it. You just couldn't. Is that right, Commissioner Mears? Ashley can't say.
It was a minimum 24 hours or whatever you set, right? Once you set it, you couldn't drop it.
Yeah.
But at any point in time, could you extend it? Is that helpful for my memory? At any point in time, you could extend?
I don't recall if you could go in and extend prior to the expiration. I don't remember.
Yeah, I don't remember that. That's the only thing I'm thinking about, Dave, just to make sure. We don't
Joe's
have
got his hand up.
We got a lot of GLI folks.
Yeah, so we made some calls, and Kevin and Joe Collin have joined us. They have very limited time window. So I'd like to go back to address the question from earlier, if we could re-ask it for Kevin and Joe. Joe Collin, Senior Director of Engineering, Kevin Mullally, our General Counsel.
Go ahead, Dave.
Okay.
You want to?
So I get the question is, should a patron be allowed to extend their cooling off period during a cooling off period, anytime during a cooling off period, or should they be required to wait until the cooling off period is expired before they're able to renew it? Or
if I could just reframe that briefly, you're saying it should, like it's a policy question. I think the issue is completely technical. Can a patron who is in the middle of a cooling off period extend?
Yeah, it's
That's
a good
technically.
question. Yes, it's a good question. And so I do want to be careful about terminology. Typically, cooling off period, when we use that terminology within regulations, responsible gaming controls, that's specific to the time after you set a limit and you look to increase that limit or decrease that exclusion. So what I mean, like if you set a $100 deposit limit and you decide I want to change that to $200, cooling off periods, usually we're talking about that will not take effect for, the 72 hours that's defined by regulation. And that's a hard to find number, and that's always from the previous transaction. But I think what we're talking about here is self-exclusion. So if I'm excluding myself from the website or apps for a period of, say, a week, and I want to extend that out to 2 weeks, does the patron have the ability to come in and self-exclude for a longer period of time? Is that the correct?
I think it's cooling off versus self-exclusion. I mean, you're not talking about the voluntary self-exclusion program, are you, Joe? Because we're talking about the cooling off periods.
Okay, so cooling off periods typically a defined set of time that is from a point of which you set a limit to which you can change that limit. So that's typically defined in regulation, and this is just the way that it exists across the U.S. today. So any departure from that would be a very big structural change. But basically, it's to say if I set a limit of $100, my cooling off period is 72 hours. I cannot make a change to that limit that would change it up, meaning to $150 to $200, so that I can deposit more money for a period of time that's hard coded set by regulation. As soon as that cooling off period's done, then I can make adjustments to that limit if I so choose. If I make an adjustment lower, it happens immediately. And as soon as I make an adjustment lower, the cooling off period now resets and is that defined period again from the point at which you make that change. Similarly, if you make a change to 150, now there's a cooling off period that said let me go back to the example. So you set 172-hour cooling off period defined by regulation, hard number. You go through that 72 hours and you say, I want to increase that limit from 100 to 150. Now a new 72 hours takes effect. So I can't change that from 150 to 200 until that defined set. But that's never variable. It's not something that the player typically has any control over, is even really aware of. It's something that's defined behind the scenes in regulation, and is only notified to the player to say, look, you're trying to increase a limit, and that you've already set. You're not able to do so until this timer goes down. Does that help address the question?
Can I just, I'll say how I'm confused. I think we were really thinking only about time away from the platform, and it sounds like you're also involving the limit on the wager amount. So I think
whether it's a limit or an exclusion, if you want to, it actually doesn't apply. It doesn't apply to the exclusion example. And this is where, again, the cooling off period is typically talking about those limit changes, and that, like, think about it before you actually, decide to increase, so that you don't set a limit and then you immediately can just reset it. That removes the power of the control. When it comes to exclusions, and that's where you're talking about time away. I want to be away from the site for a set period of time. You can always add to those.
You can always add.
Yeah,
okay.
But that's that voluntary exclusion process, and you should be able to access the site and withdraw funds and be able to change that exclusion amount. But you wouldn't be able to do anything else.
Kevin's got his hand up, so I'm going to turn to Kevin.
Hi, hello everybody. It's been a while. I've been on the road a bit. So Joe, just let me frame the policy issue, and then I'll turn back to Joe on the technology, because it involves my understanding of the issue is that the rule essentially hard codes the options. It says you can do 72 hours, 1 week, 2 weeks, 3 weeks, 4 weeks, etc. And the comment from at least one of the operators was, That's not really the way our system works. We have all those.
And we've gotten rid of the
Okay.
time. Okay, we
Okay.
took care of that. So
Okay.
now Dave Mackey is framing, we took care of that, we took care of the prohibition. So now the only thing we're wondering, and it's really just my simple question, if I'm a patron and I established a 3-week cooling off period, don't want to go on the platform at all. Not voluntary self-exclusion, but just that 3-week period. Can I, on week 2, is there any technical challenge to increasing it to 4 weeks?
Yeah.
As long as, the universe is set by regulation.
Yeah, and I'll let Joe answer the technology part of that. My guess, but the research, as I understand it, is fairly consistent in that you should provide the gambler with as many options as possible, because nobody's path to recovery is the same, and a one size fits all, you have to go this way, is not preferable. But Joe, I don't know that.
And I think Mark Vanderlinden would agree, and then I think that Mr. Mackey also promoted. So I'm just asking, is it a tech issue at all? It must not be, if everybody understands that.
Yeah.
Should be a tech issue. Raise that. Yeah. Should
Joe?
not be a tech issue to
Okay,
increase.
excellent.
Yeah.
Excellent. That's all I needed. Yes, Mark. Yes.
Madam Chair, thank you. And I apologize. I was in another meeting and just hopping in here. Yes, options are good. Simplicity is also good. And so making enrollment as clear and easy as possible with as few clicks as possible is what is really important. The original requirement of providing a limited number of options is really to kind of create that the fewest clicks possible, the easiest enrollment possible. If we're able to give options to patrons and make it easy, I would support that. I also think that allowing individuals to extend their cooling off while they're still in that cooling off, not at that period when it's over and they're just one click away from placing a bet, when they're still in that cooling off, cool state of mind, giving them that option is very important.
Yeah. So I don't think anybody is, I think we're all on board for policy, but we need to revisit that. So it had nothing to do with the policy behind it. I just wanted to know before we signed off and that it would not present any tech challenge. And it sounds like it's not going to, which is.
Okay. I'm glad. Sorry. Again.
No. But Mark, we knew where you were coming from, and Dave Mackey did a great job relaying your position. So, but thank you. And thank you, Kevin. So mystery has been solved. No tech issue. Thank you. Thanks so much. And GLI, thank you, because you just scrambled really fast for me, and I appreciate it.
With that, I'm going to I'll let Joe dismiss himself here because I know that he's under a different schedule. Okay.
And everybody
well,
can.
I'll be here. Okay.
Yeah, Commissioner,
Kevin
do you
as
have
well.
any follow-up questions for Joe Carlton? I think we're all set, right? Thank you so much, Joe.
Yeah,
thank you.
Absolutely.
I do have a follow-up for Dave. Sorry to cut you off, Madam Chair.
Oh, no, go right ahead.
Just in light of your comment about, perhaps the comment from DraftKings crossed with the changes that we saw yesterday in this set of regulations, I want to renew Commissioner O'Brien's request from yesterday to add the date to these comments, because I think it would be really helpful, and we might have ascertained, it just might have been easier to get to the better understanding of the timing of the comment.
I think that I might have asked for the date. I think that was me. So thank you, Commissioner O'Brien. I think
I was the highlight requester.
Oh, okay. Yeah.
She's a highlight, and I was the date because it does add a little context.
Yeah. Well, thanks to both of you, because it would be helpful if our legal team could swing that.
We'll certainly do both moving forward. There was obviously quite a backlog of comments that we didn't really have time to handle yesterday, but moving forward, we'll be sure to do both of those things.
Yeah. Thank you so much. Yeah. Okay. So I took care of that, Dave. Sorry, it was a diverted, but I just wanted to make sure we didn't cause something with that inadvertently. So, all right. So, is there anything else on that?
We've gone
Okay.
through the 5 new comments, and I think we've had an opportunity to discuss them all. I'm sorry, 5 plus the FanDuel letter, which was duplicative of the issues that we discussed yesterday.
Yeah. Yeah. Okay, commissioners, any further questions then on this one, on 254? We certainly have looked at it and thought about it a lot and had we also had real-time input from the applicants. So if not, if there are no questions, do we have a motion?
Yes, Madam Chair, I would move that the commission approve the amended small business impact statement in the draft of 205 CMR 254 as included in the commissioner's packet and discussed here today. And further, that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
That's from Commissioner Skinner. Any questions or edits? Okay. Oh, Commissioner O'Brien. Excuse me.
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
And I vote yes. So 5-0 on that. Thanks everyone for tolerating my question. All right. So now we move back to 247, right? Karen?
That's right. And Paul Commoners will pick this one up for us.
Hi, Paul, and if you can direct us to the right page, that would be great.
Good afternoon, commissioners. The first thing that we're going to discuss appears on page 169.
Thank you. Rosen. Go right ahead, Paul.
We're going to withdraw this recommendation. So on further review of this regulation, the comment, Maine and Ohio's corresponding regulations and the advertising regulation, we realized that what we think is causing some confusion for BetMGM and what was causing some confusion on our end as well is that this regulation requires in its first sentence that material terms be disclosed in one fashion, that all terms be disclosed in a different fashion. And in the last sentence sets out a list of terms that must be disclosed without specifying whether that's the list of material terms or the list of all terms. After reviewing Maine's regulation, which Commissioner O'Brien is correct, does require that all material terms be disclosed on the face of the advertisement. It appears that this list is the list of all terms that must be disclosed and that the regulation does not define the list of material terms. However, there is a provision in 256 that does appear to set out a list that functions as a list of material terms. And so given that this does not appear to create the problem that BetMGM was concerned about and that we would want to make any changes here to define a list of material terms. In parallel with changes to 256, we are no longer recommending this change and we'll take another look at the list of material terms along with 256 when it comes back, I believe, later this month.
Thank you for going back and looking at the other states, the other jurisdictions, Paul. Questions for Paul? Commissioner O'Brien?
I just want to make sure I'm following. This is say 169 in the packet.
That's correct.
To 47.092, the language in there, right?
Correct.
Okay.
It was Maine, Illinois, maybe.
Maine
Ohio,
was,
I think,
I
right?
looked at Maine and Ohio. Maine is the most relevant. I have it up if you'd like me to share my screen. But in short, Maine requires the disclosure of a quite similar list, but it breaks out the provisions that list the
that establish the list of all terms that must be disclosed before a patron accepts a promotion and includes the similar list there. And it has a separate subsection that requires disclosure of all material terms on the face of the promotion.
Questions, comments? Okay, what else do we have, Paul? That's it, right?
We have 2 new comments on page 1. Well, one comment with 2 parts on page 172.
Yeah.
We do not recommend any changes in response to these comments. The first comment is in the first comment, BetMGM expresses its opposition to a requirement for tier 1 for the use for a requirement for the use of official league data for tier 1 wagers. I've reread the regulation. I don't believe the regulation requires official league data be used for tier 1 wagers. And the particular place they propose removing the language tier 1 sports wagers and from is a sentence that says except as otherwise provided, operators may use any and all data sources approved by the commission in effect. So removing this language would give them less flexibility than they currently have. The second proposal is to not require the licensure as sports wagering vendors of providers of data sources. We think it's important for regulatory purposes that providers of data be licensed as sports wagering vendors. And in fact, the definition of sports wagering vendor in 205 CMR 202 includes entities providing data to operators. So we don't recommend adopting this comment either.
Questions for Paul on that one? Or the other? Okay, the next.
That's everything on 247.
Yeah, Mr. Williams. Okay. So commissioners, in terms of 247, any further questions that you didn't address yesterday? We really didn't have any other changes, right? Just that one, or wasn't there at the beginning, Paul?
Yes, we did add a provision requiring operators to provide version of house rules that were previously in effect to patrons.
And that's on 156. That would be the only change if you're taking out the other one, right?
The only substantive change. There are a few fixes to typos and cross references and missing, and one instance where the word transaction was missing.
So commissioners, are we ready to move on this, or do you have questions for Paul and team? I'll take a motion.
Madam Chair, I move that the commission approve the amended small business impact statement and the draft of 205 CMR 247 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Any further questions or edits? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Excellent. $248. Who's going to handle 248?
You're stuck with me again, Madam Chair.
I like that, Paul. Let's see. Now bring me to the right page again, please.
248 picks up on page 186. Our first substantive edit appears on page 188.
One. For some reason it's not letting me edit page number. Okay, turning to 188. Go right ahead, Paul. Thank you.
So as a reminder, just to make sure everyone is properly situated, 205 CMR 248 governs the creations, maintenance, suspension, and abandonment of patron sports wagering accounts. As with 247, there are only a few substantive tweaks, in this case, 3. So this first tweak on page 188 responds to a request to make it clear that the operators need to maintain records on a patron's acknowledgement that only they may use their sports wagering account, consent to the monitoring and recording of the use of the sports wagering account, and affirmation that the PII the patron provided is accurate. And this language ensures that the operators retain that information. The next tweak will be on the top of page 189. GeoComply recommended that we shorten the time period to re-verify a patron's account, potentially compromised patron account. The sports wagering division agreed, so we had accepted this recommendation. Our next and final substantive edit is a ways down on page 196. One commenter suggested that patrons whose accounts are suspended should have rights to be told about the reason for the suspension. While we understand the desire for transparency in this area, the difficulty is that many account suspensions will involve integrity or other enforcement issues, and giving away information or refusing to give away information may reveal the existence of an investigation or otherwise compromise an investigation. After discussion with GLI and the sports wagering division, we settled on requiring operators to inform suspended patrons how to submit a complaint, either both with the operator and with the commission, as discussed yesterday. That smooths the path for patrons to raise legitimate concerns about their account suspensions without running a risk of undermining enforcement. If there are no
questions on that? Sorry, Paul, I was just going to ask the commissioners, are there any questions on that? All right.
The comments start, oh, pardon me. The comments start on page 198.
Thank you, Paul.
So these first two comments correspond to the edits that we've just shown you. The first is the comment from GeoComply. The second is the comment from the member of the public concerning account suspensions. The first comment we do not recommend adopting appears towards the bottom of page 199. BetMGM is asking to be allowed to use hashing instead of encryption for certain purposes. GLI assured us that the encryption requirement is a standard requirement imposed in other jurisdictions that the BetMGM should be able to comply with. The next two comments from BetMGM ask that they be instructed to destroy patron PII that isn't necessary for legal and enforcement purposes. While we appreciate the spirit of these comments, as we appreciated the spirit of a related comment from BetMGM on 247 yesterday, we were slightly puzzled by these because we think that all of the information that we're requiring operators to collect is potentially useful for legal and enforcement purposes. We're concerned that adopting the suggestion would introduce confusion about that fact and invite operators to make their own judgments about what they can destroy and potentially destroy PII that we need them to retain. So we do not recommend adopting these suggestions. The next comment from BetMGM is about the sharing of patron information. We don't fully understand at this point how much of a burden this proposal would impose on other operators, or even how useful this would be to patrons. So we don't recommend adopting this comment. If there's interest from the commission in investigating what the impact of this comment would be, I would suggest that we start by incorporating it into a discussion with the Data Privacy and Security Division, as Commissioner O'Brien suggested earlier.
Questions on that one? Okay.
So the next series of comments from GeoComply are asking to add monitoring and consumer protection measures that are already covered elsewhere in the regulations. So I'll give you two examples. This first comment at the bottom of page 200 suggests that we instruct operators to develop capacities to prevent proxy betting, but this is already covered in 205 CMR 238.32.4. The next two comments, which suggest that we define multi-factor authentication and require it in certain circumstances, is really already subsumed within our adoption of GLI 33. So we don't recommend adopting these comments from GeoComply.
Paul, could you just cite the proxy where we cover that issue and the other reg too?
Yes, it's in 238.32 subsection 4.
Did we get back to GeoComply by chance? No, because it just came. These came into us, right? Just wondered if they had missed it and wondered what they thought of. I'm thinking about the proxy betting issue.
It's not a new comment, Madam Chair.
These comments came in relatively late, but not at the last minute. I would have to check on the exact date.
Well, we can circle back to GeoComply and just have them look at the language that we do have in case they missed it.
Given the length of 238, that's certain.
Because many of us saw that there was a proxy issue in another jurisdiction, so we want to make sure we're thinking about that.
So if I may, I'd like to move on to the three final comments from BetMGM, which pick up on page 204, but I would recommend that you look at the third comment, which is on page 207. So these comments all address the escheatment of accounts. BetMGM is asking the commission to add a login to a sports wagering account to the list of possible activities that prevent an account from escheating. So I want to start with a little bit of background on how we developed our approach to escheatment. In an August 31st letter to the commission, Treasurer Goldberg asked the commission to ensure that accounts escheat after a period of inactivity because there were concerns that sports wagering operators have not let accounts escheat in other states. And the treasurer specifically encouraged us to review Iowa's regulations in this area. Consistent with Iowa's regulations, the forms of activity that prevent an account from escheating are withdrawal of funds from the account, a deposit of funds from the account, or a wager. And BetMGM is asking us to add a login to this list. So they present a few arguments, some of which claim that there are conflicts with other state law and with federal law. And because the arguments involve potential conflicts with other law, I would like to take them one by one to be very clear about our reasoning and why we see no conflict. BetMGM's first argument is that this conflicts with the definition of activity in the Treasurer's general regulations on escheatment, 960 CMR 402. We We don't see that. The treasurer's regulations list a series of activities that demonstrate an owner's interest in maintaining control of an account. They don't define logging in as sufficient. Every activity they list reflects a heavier lift than simply logging into an existing account. Also, again, our regulations are, the list of activities in our regulation is consistent with the list of activities in Iowa, which is the regulation the treasurer specifically called to our attention. So I'm not concerned there's a conflict with the treasurer's regulations. The second argument that BetMGM presents is that this conflicts with an SEC guidance on escheatment. I've reviewed what I believe to be this guidance, and there are several reasons I don't see a conflict with our regulations. First of all, it's the SEC. It's concerned with brokerage accounts, and sports wagering accounts are not brokerage accounts. Second, this guidance doesn't establish any law. It appears to be an informal advisory document for the benefit of investors. And it even explains that state law, not federal law, governs escheatments. So it's not making law that would govern accounts, even if it governed sports wagering accounts, which it does not. So I don't see a meaningful conflict with the SEC guidance either. BetMGM's third argument is that requiring owners who are not in a financial or emotional position to engage with their accounts to engage in activity in their accounts presents a responsible gaming issue. But they overlook the fact that they insist that the only way to keep an account alive is to add funds or place a wager, which would present a serious responsible gaming issue, and ignore the fact that withdrawal of funds is a permissible form of activity to keep an account alive. Also, if someone isn't equipped to log into their account and initiate a $1 withdrawal for 3 years, we would probably prefer that person not to log into their account at all, and we would prefer that account to escheat as soon as possible. Finally, although BetMGM clearly feels strongly about this regulation, we haven't heard from any other operator or member of the public on it. So for all of those reasons, we do not recommend adopting BetMGM's comment on escheatment.
Questions for Paul? Are we all set with Paul in terms of going through all of these comments?
Yes.
No, thank you, Commissioner Hill. I appreciate an affirmation. All right, thank you so much. So I'm not hearing anything, Paul. Commissioners, we've gotten through, that would be the final reg, I think, for today, which was our homework, although we've marked up for another discussion. So if there's no further questions, we could move on that one.
Madam Chair, I would be more than happy to do that.
Thank you.
I move that the commission approve the amended small business impact statement and the draft of 205 CMR 248 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize regulation promulgation process. Let me rephrase that, Commonwealth to finalize the regulation promulgation process.
Second.
Okay, any questions? Okay, Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
I vote yes, 5-0. So we've taken care of all the regs that were before us, correct, Caitlin and Carrie?
That's right. Thank you.
Okay, now we have marked up time for the discussion around the sports wagering vendor and sports wagering advertising regs. We also have reserved time for tomorrow at 1. It is 1:23. I just checked our calendar and this meeting was intended to conclude, about 8 minutes ago. I'm not sure what the time frame, how it was decided, but that's what I have on my calendar. I think even if we want to go to the other, I would need to take a little bit of a break. So that would only make a date later, and I suspect my fellow commissioners would want a bit of a break. So commissioners, are we ready to adjourn today? I see Karen Wells is leaning in.
I just, for the commissioner's edification, I did check with Mark. I know you have sort of a hold on your calendar for something with respect to Game Sense. So he indicated that that certainly was not mandatory. I would expect that this matter could take precedence. So I did check the commissioner calendars. That's the only thing that I could see that would prohibit you from going forward today. But I'll, of course, defer to the commissioners and what they want to do.
I'm sorry, because I think I was traveling. My records may not be great. What am I missing on Game Sense today? I didn't have it on the agenda.
Yeah, there's a sort of a Game Sense strategy meeting, but Mark indicated the commissioners are invited, but that's all.
Yeah. So yes. So yes, if we wanted to, did that get canceled or?
He can cover that. So
he could cover it. Is that what was the issue?
I don't know. That's the only thing I'm seeing on commissioners' calendars that sort of bumps up against this time frame.
Oh, well, we're still getting used to our scheduling because typically for internal meetings like that, even though that's external, we go around. So commissioners, what would you like to do? We can take a break and continue on and then clear Thursday. Commissioner Hill, what would you like to do?
You're looking for an opinion. I would love a break and I would love to come back and see if we can finish these off today. Okay. But I have a hard stop, but I do have a hard stop at 4:15.
Okay.
Yeah. I need lunch. I'm glad I'm not the first one to say it. Thank you, Brad.
Yeah,
Well, if anybody ever needs that comment, just say Brad can check in.
I'll just pull on my ear and you can say that you need to eat. Yeah, I do. So I have a lot of thoughts on these two in particular. And my question, Karen, is Mark saying he's going to be otherwise occupied? Because I'd love him to be part of this.
Ooh, that's a good question.
And, or if not, we can have the conversation and maybe there's a short meeting tomorrow afternoon to sort of circle back on this stuff and vote. That would be my thought, because I've had some conversations with him and Brianne and just looking at some stuff myself. So I just want to make sure he can be part of the process.
I can run it fast.
Yeah, because otherwise I probably would have everything roll over to tomorrow rather than us.
Yeah.
I wouldn't probably do both.
I might just note that we thought this was ending at 1:15, so our outside counsel have some commitments starting at 3. So we'd like them to be here if possible. But.
So maybe we just take a break, go till 3, and then.
No, they are not available until 3. Is that what you just said?
No, sorry. They are available until 3.
That's what I thought. No, yeah. So we just would take a half an hour and then we'd have an hour. Then I'm sure that our legal team could also cover.
Right.
All right.
Can someone also check to see if Director Lilios is available for the vendor regs? Just in case.
That's a good point.
Questions. She's not on the meeting currently.
I don't believe she's available today. But
hey, everybody.
Hi, Heather. How are you?
I'm well. How are you?
Well,
hey, I just wanted to let everybody know, Kara O'Brien and I are both going to be available for the discussion on the vendor regs. We've touched base with Loretta and we will both be here.
Okay.
All right.
Karen?
Mark is available if you want to take a break and then come back.
Yeah. All right. We'll reconvene this meeting at, let's do 2:00, and we'll have a good 1-hour discussion on this matter. We know that outside counsel is not available after that hour. So thank you, everyone.
All right.
Okay, Mills? Thank you.
You're all set.
Thank you so much. I think we're turning now to page 222 of our packet. I'll turn to Todd and Caitlin. I'm not sure if you're leading this discussion, but just to remind everyone, we had a very productive roundtable on Monday from most of the stakeholders who have submitted comments to us. We were very fortunate to have so many participants from the operators to the third-party affiliates. We also had a representative from NESN, and we had a member of the responsible gaming experts who we had heard from earlier in our responsible gaming roundtable. So before we get started, I have to do a roll call. So Commissioner O'Brien, good afternoon.
Good afternoon. I am here.
Great. Commissioner Hill, good afternoon.
Good afternoon. I'm here.
Commissioner Skinner, good afternoon.
Good afternoon.
And Commissioner Maynard, good afternoon.
Good afternoon, Madam Chair.
Right. So as I said, this discussion is a result of that roundtable, and we decided to bring it up from next Tuesday to today or tomorrow because the invested parties did say that time was of the essence for them. Should we either reconsider our regulation or whether it stays the same, they just would need some finality for their business purposes. So it was no problem for us to accommodate that this week. So I see Paula's back. The commissioners can tee it up or legal, we'll turn to you. The one thing I wanted to know is that in the packet, the PowerPoint that was presented by third parties is not included. I believe, though, that has been put out into the public sphere somewhere. I want to make sure that public document is at least out there. Certainly, folks got to see it in real time when they presented it.
I believe that's correct, but we can double check.
And Chair, I'm happy to work with the legal team to get that PowerPoint up on the website in the next 10 minutes.
Okay, excellent. But that's just another resource that we have. All right. Thank you.
So I am happy to set this up from a regulatory perspective, just the way the regulations interact with each other. So as the chair mentioned, there was the roundtable about the sports wagering advertising regulation, and in particular, that is 205 CMR 256.013. That specific paragraph is where the conversation was focused, and that's on page 233 of your packet. Depending on what the commission, and I should also note that the packet does include all of the comments that we've received on that provision to date, not the PowerPoint, but we can add that. Depending on what the commission decides to do with regard to that section, whether it decides to allow cost per CPA, cost per acquisition agreements, revenue sharing agreements, or some combination of the two, that would then have an effect on the vendor regulation, which we can discuss separately, but that's why this is first. So the commission can decide what it would like to do with the advertising reg, and that will impact the discussion on the vendor reg.
Yeah, it is. There is intersectionality there, and that's why the agenda marked it up. So we have both regs in our packet as well.
And one other thing I should note, Chair, is that the advertising reg is still in the promulgation process. It comes back for a final vote on the 23rd. So to the extent that the commission wants to issue any waivers to the specific provision, a waiver can be issued today, but and that can then be incorporated when it comes back for a final vote on March 23rd.
Right. And the vendor reg?
I was going to ask that. When's the vendor reg?
The vendor reg is in a different situation. So the vendor reg was one of the first regs. I think the second reg you saw. So that is fully in effect. So what we're doing today is bringing that back for an amendment. So this would be, I believe, the first amendment to the vendor reg, and we would then start the promulgation process If done by emergency, it would be the same way that we've been doing it. We put it into effect right away, get comments, and move it through.
Okay. So who wants to just remind, maybe it's Caitlin, maybe it's another member of the legal team, the status quo, where are we right now? And then and we actually gave some advice on what the reg does right now. And then we had a lot of input from stakeholders, and that's why we held the roundtable. Go ahead, Caitlin.
Absolutely, happy to do that. So we had received a number of questions about what exactly 256.013 did. And so upon reviewing the reg, we issued a clarification that what that provision does is it prohibits third-party marketing entities from entering into contracts with the operators that involve revenue sharing agreements that are based on sort of the number of patrons that actually sign up for an account or the amount of money that a patron wagers on an account. And it would also prohibit, it also does currently prohibit cost per acquisition relationships based on those same factors, a cost per acquisition of based on the number of patrons that sign up for an account or the volume or number of wagers made by a patron.
Okay, and then the intersectionality issue. Can you explain why?
Absolutely.
You have the other reg, please.
Absolutely. So the vendor reg is coming back. It was going to come back anyway. It was going to come back because after learning more and going through this process, the IEB and licensing division wanted to provide some more clarity with regard to the definition of third-party marketing entity, and then also to suggest a change to the licensing versus registration requirements. Currently, all third-party marketing entities are required to be licensed. There is a waiver in effect for now that, in fact, the commission decided that they did not need to be licensed for this period of time. They're being registered. But licensing and the IEB would like to formalize that. The twist comes in where if the commission decides today that it wants to allow cost per acquisition relationships, the IEB, and I'll let the IEB and licensing talk about this more specifically, but they would recommend continuing to require or formalizing the requirement of registration for those entities. If, however, the commission decides to allow revenue sharing agreements, those are larger, potentially more serious agreements, and the IEB and licensing would recommend that there is actual licensure of those entities that enter into the revenue sharing agreements. And so when you look at that reg, after this decision is made, and we look at the reg, we can show you what language would be used in each instance, or at least the language that we are recommending in each instance.
The options. Okay, so that sets the stage a little, and a reminder, it was just Monday, but we've done a lot in between. So commissioners, I'm going to just sort of take the temperature, if you don't mind, so that we can find out and maybe help our team know where we're coming from. Commissioner Hill, can I turn to you?
I think you can. And I've been giving this a lot of thought, and I actually have a lot of questions. And I think before I make my comments, I think I see Mark on the meeting. I think I need to hear a little bit more about how the third party and revenue share affects our RG stuff. Because I think what I heard Monday is it doesn't as much as I thought it might. But I want to get clarification about that.
Mark,
you're on mute.
I tried to hit my mute button before you had to say you're on mute.
No problem.
Commissioner Hill, could you be more specific how it affects, when you say how it affects RG? I think I just...
If we allow cost per acquisition, revenue sharing, tell me how that might affect our responsible gaming. Because I think the issue is that we may be going after a certain population we're not trying to go after, but we may end up going after a portion of the population that you're concerned about, and we're all concerned about.
Yeah, so I'll answer this the best I can and kind of on the fly here, Commissioner. And I think it relates a little bit back to some of the other concerns that we had and that we're trying to address in other parts of that regulation. But what is the ability to protect vulnerable populations? How do we, in working with or regulating licensing, marketing affiliates, what effect does that have on our ability to control what marketing is out there? How saturated does the market become with advertising when we open up the door wide open to marketing affiliates? There are specific protections that are captured within 256 elsewhere that are really important to us, and assuring that that this is happening across the board is important, and does allowing marketing affiliates or opening the door wide open to marketing affiliates affect our ability to enforce that. I think that there is, to say what difference does CPA versus revenue share make. I wish I was more versed in sort of what are the pros and cons of both of those. But bottom line is, I think that whatever direction the commission goes, that our ability to enforce it and to make sure that all parts of that regulation are enforced is really important.
So that's how I felt. I felt that as though we are protecting our most vulnerable bettors with the regulations that we have in place. And the more thought I gave to this, there are other industries that are also vulnerable. I would think about alcohol and I would think about marijuana. And after our discussion on Monday, I actually went and Googled what is the best small brewery in Massachusetts. And you should have seen what popped up. I then went and looked, where's the best marijuana or shops in Massachusetts? You should have seen the information that came up when I Googled it. And I think we have better protections in place through our current regulations than those other industries. And I don't know the answer to that. I'm putting it out there. I don't know what the regulations are for the cannabis control. I don't know what the ABCC has in regards to market affiliates and revenue share and third parties and all that other stuff that goes with it. But the more I thought about it is could be disallowing a whole industry that does business now in Massachusetts that they wouldn't be allowed to do if this regulation was to move forward as is. And I don't think I've gotten enough data to tell me that there's a problem that we're trying to address here by not allowing marketing affiliates and third-party folks to come into Massachusetts for this particular industry, which is disappointing to me, not because nobody could get it to me, just because I don't have it. I love the data that this commission gets us when we're making decisions. So my thought process, Madam Chair, as of right now, is I would have no problem allowing marketing affiliates to come in. I have no problem with revenue sharing and other ways of paying until I can be convinced that there's a problem we're trying to address. And I think I heard Mark say that we really don't have the pros and cons to this yet. I think in the future we're going to, for sure. But I think as of right now, I'm not sure why we have this in place. And removing it would probably be something I could support today, knowing full well that we could bring it back for a discussion at another time if there's an issue that pops up that we need to address. Thank you, Madam Chair.
Okay, can I just do a follow-up? Mark, you did hear Breon's comments, and she's a colleague, shared colleague, and somebody that you respect. Maybe you can, at least for the public's purpose, if not for all of us, to sort of remind us of some of the highlights of her contributions.
I'll do the best I can. I mean, I think Brianne's take was, marketing affiliates, that allowing affiliates isn't necessarily bad. And in fact, there are in some ways it's a positive in the market. And so I don't think that she would argue that eliminating that altogether is a good thing. I think that Brianne also would provide some caution about how far you open the door, or what there should be rules around how marketing affiliates operate, which would be exactly the same of how we're holding our operators accountable. Marketing affiliates need to be held accountable as well. So, I mean, Madam Chair, that's it in a nutshell. I think it's not. Her point was it wasn't all a bad thing.
Yeah, and if I recall correctly, she had worked closely with the third-party affiliates that were represented, and did suggest that they provide RG information that you might not get elsewhere. I think we heard quite a bit about the challenge of legitimate third-party affiliates versus dealing with offshore marketing. And so that challenge of black market versus a regulated market, I think she addressed that. She was, I think all of us agreed, she was a very valuable contributor to that conversation that day. We were lucky that she could make it on short notice. On your latter point though, holding the third party responsible, I mentioned the other day, and I think this is a strength in our reg, is that we start with, no matter at the end of the day, whether it's third party or any other vendor, the sports wagering operator is always going to be responsible for content, advertising, marketing, branding, content, and conduct of all of that. It falls on the sports wagering operator on 256.01 subsection 1. So just a reminder, whether we want to reiterate that for the third party, that would be good. But at the end of the day, I think we all recognize that the sports wagering operator is in charge of their strategies and content. So I'll just turn. Commissioner Hill, I didn't mean to put you on the spot, but I just thought it's a good way to get the conversation rolling a little bit and remind us of our challenges. I see Commissioner O'Brien, you're leaning in.
Yeah, so to Commissioner Hill's question in terms of why it's even there, I can say that the reason that language is in there in the third-party marketers, I can take responsibility for some of that in terms of putting it in front of the five of us early on. One of the last trainings that I was in prior to the legislation being passed, a regulator in Michigan commented on this was probably one of the areas to try to be the most aggressive on to stop saturation of the market. For the annoyance factor to the people that don't want to have anything to do with the industry, and then also to protect the vulnerable, as you were talking about. And so we put in a number of things, like the chair said, the operator is ultimately responsible for this person's conduct, regardless of what, the contractual relationship is. So I've been trying to educate myself on this more and more. I actually called Brianne after that meeting because I had a lot of follow-up questions on what is the difference between cost per acquisition, revenue share, that sort of thing. What are other states doing in this regard? So one of the things that I took out of that meeting and that I said to Brianne was the intent of what we wanted to do is stop saturation and protect the vulnerable while allowing them to market. And it seems that the language we put in may have the opposite effect. So it may be that what we're doing is, incentivizing the operators to then do mass inundation of the market, which is going to increase saturation, which is what we don't want. What I did not take out of that meeting, however, is we should just eliminate the restrictions that we put out there on CPA and rev share without other controls, because I don't think that's going to solve the problem. I actually think it's going to create more issues. So the question I had is, what are other jurisdictions doing so we can address the fact that how we have it written is probably going to be the counter effect of what we wanted. But I don't think eliminating it is the solution. I mean, New York State's literally simultaneously when we were having that roundtable voted to ban rev share. because the inherent conflict of interest and the inherent motivation to get people to bet more on a rev share agreement is counter to the RG that we want to have and the protection of the vulnerable people. So the people that participated in that roundtable were some of the most active in terms of RG in that field, in that area. And Brienne said that. What I do want to point out, however, is they're not the only actors. And my takeaway from the conversations with her as well is some of the most predatory behavior and the most negatively impactful behavior come from smaller players who come in and out of a market quickly to maximize maybe a cost per acquisition or rev shoot, and then they go. Maybe they get banned, they reincorporate, they come back in. So to the extent that we're considering changing the reg to allow CPA and or rev share agreements, there's a lot of options that we have to put countermeasures in place to try to eliminate that lower hanging fruit, for lack of a better term, who I think probably propagate the worst damage on this. And there are a lot of different ways to do it. My understanding is Kansas actually caps the number of third-party affiliate contracts each operator can have, which by nature would maybe, cap the number of these people that are going to be in the state. Licensing them, I think, is absolutely critical. It makes sure that you're getting, a suitable corporation. Looking at, and this is a question that I have for licensing and Karen Heather, which is the comment Brienne also made to me is the costlier the license, the more of a commitment the company's going to have to make, and the more of a commitment they make to the Commonwealth of Massachusetts, as opposed to a de minimis fee, a registrant process, maybe an easier process where they can churn and burn, get profit, and take off and do some damage and then leave. So licensing them, making sure the licensing fee, and I'm not sure what that structure is. I know that's somewhere else in the reg, making that have some teeth to it so people aren't going to want to make a commitment when they put in for the license. Potentially capping the number that each operator could have to try to keep the number such that we're, only ideally getting the best operators in this area. There's the concept of potentially doing reporting requirements. And this is another conversation that we can have, because this question of whether they help or hurt as well, to me is, and I think the timing is fortuitous. We're coming up with our research agenda. I would love to have something that has some sort of reporting come in from the third-party market affiliate data that then feeds some sort of research about the impact. So that's something that I think we can talk about. And then I also want to look at New Jersey and Colorado, who have said that, to their point, they don't have the PII, the third-party marketer themselves don't. However, the operators do. And to put something in place in another reg, either freestanding or in the RG reg, that requires them to take that data that they're getting, look for trends, and try to do intervention and RG protocols based on that information. So this to me is not so simple as, do we say, yeah, we're just going to strike that and allow CPA and rev share? I absolutely think there is a place for those third-party marketers in this environment, but I think this is a much more complicated conversation than just, okay, do we strike it? I mean, you could also, the argument that rev share is necessary for sort of maybe some smaller legitimate companies like the one who participated in the call. But once you're up and running, do you need to continue to have rev share where you're in that inherent pushing people to do betting to make your money? So is there a time limit or a sunset on rev share when somebody enters the market? You can do it for the first X time. The expectation at that point is you can go off and running and be cost per acquisition. There wouldn't be a need for rev share. So there's a lot to unpack in what I've just said, but at its heart, I don't think we should be eliminating the ban on it unless we're putting countermeasures in place to make sure that we are getting the most responsible and beneficial third-party marketers into this.
Thanks. I'm going to have Commissioner Skinner, and I'll turn to Commissioner Maynard. Commissioner Skinner.
I don't quite know how to follow that, Commissioner O'Brien. You raised some excellent points. I have a couple of questions to start. So I think I'm pretty clear on the CPA side of the house, but I could use a bit more education on the revenue sharing component. I I am not clear on the distinction between the two agreements. So I don't know if anyone participating in this meeting could shed light on that. If not, I'm happy to take advantage of the resources we have in Brienne, as Commissioner O'Brien mentioned, to kind of come up to speed on that.
I think we should be able to answer that. That's it's more legal than RG. Does anybody want to, any of our legal team want to explain the difference between the CPA and the revenue share? You must have all been thinking about it.
I can give it a try unless Paul wants to go
Thank you,
first.
Caitlin. Yes.
So the CPA is more of a one-off situation, right? The third party, if someone clicks on the third party marketing entities ad, clicks through to the operator's website and makes an account, let's say, they get $5 every time that happens, right? So it's sort of a one-by-one process. My understanding is that the revenue sharing is based on, they're actually sharing a percentage of the operator's revenue. So someone clicks through the website, becomes a patron and bets $100, they get $10 of it. And then they bet another $100, they get another $10. So that's the issue, is that they're actually taking a percentage of the earnings based on each bet.
I kind of think about it from like the acquisition, they're getting a customer versus making money on finding a customer versus making money on activity by the patron. That's kind of a real simplistic view I've taken on it. Commissioner Skinner, is that kind of fair to the legal team?
Yeah.
Yeah.
I mean, it sounds pretty simple, but I know it's not. I mean, we did our best to, educate ourselves as a body and holding the round table. But I don't know, that we are as informed as we probably should be as we're taking a position on whether to keep the language in this regulation or not. Another question that I have is, we heard from the representative group of marketing affiliates, but are there other marketing affiliates? And I asked that we didn't hear from, that may be perhaps the bad actors that we're concerned about in terms of oversaturation. We heard from our participants on Monday that they utilize a pull system of advertising as opposed to the push system of advertising. And at least in my mind, I can readily favor one over the other, the pull versus the push. But are there marketing affiliates who that we're talking about here that use the push method of advertising? And so, if the answer to that is yes, I 100% agree with Commissioner O'Brien that we shouldn't just be eliminating the language prohibiting those agreements without proper controls, because as much as I, can appreciate the good, right, the positive that the marketing affiliates we heard from Monday bring to the ecosystem in this industry, I also can appreciate that there's a different side of that goes against exactly what the commission and even those participants on Monday were arguing that we should not entertain. I agree with Commissioner Hill in that I don't really know what the problem is that we're trying to solve. I mean, I understand why the language is in there. Commissioner O'Brien reminded us just a minute ago. I'm not sure that the solution, however, is to outright prohibit those agreements. What was very persuasive to me is Brienne's, is her thoughts around the issue. And, she kind of sided with the operators here and the marketing affiliates here. And that was important. Her position was important to the discussion, very important to the discussion. And so I'm don't know that I have that I'm ready to take a vote on this just yet. But I'm really turning to my fellow commissioners and the team to kind of help me develop a little bit more into a better understanding of what direction we should be going in. I certainly would be in favor of entertaining a waiver of some sort, because I understand these regulations are currently in place now. But I do think there is a significant amount of discussion remaining to determine whether or not, if we're going to have these vendors licensed, what the level is going to be. The other question I have, I think it's the last question I have, is we heard about Connecticut and Illinois. If I remember correctly, Connecticut prohibits CPAs and revenue sharing, and Illinois prohibits revenue sharing. And so does anyone, do we have an understanding as to why that is? Are they consistent with our thinking in drafting this reg, or is there another reason that they are asserting, if we know?
I don't think
New York
we
to the
did
no
that
rev
research.
share now.
Okay.
I don't think we did that research. We can certainly do it. But I do know that we modeled our language after those two states.
Okay, it would be helpful to kind of understand their thought process a little bit. But that's where I am, and I don't know that I made clear where I am, but I'm still struggling a little bit.
Commissioner Maynard.
Thank you, Madam Chair. First, thank you for facilitating the roundtable on Monday. It was extremely helpful in understanding the issue. And to Commissioner Skinner's point, I got a quick education from the folks at the roundtable on the difference between Illinois and Connecticut when I got the two confused and how they were going about business. So learned that one the hard way. I like others, I listened to Brianne from the RG perspective, and was heartened to know that we are the strongest when it comes to RG protections in the country. And that really sets me at ease. I think that Mark and his team are the best in the country. And I think that, we have the ability to think and think differently. There was some information that was provided before that roundtable about the push versus pull advertising. And that was very, very instructive to me, because worrying about the proliferation of advertisements, it's different when someone goes to Google and searches something versus when it's just on the television or it's on, just on the radio. I've seen them in print. And so someone who Googles, best sports wagering app in the Commonwealth is going to get a result. That's what I learned on Monday. And the question is, who's on the other side of that result? Is it an offshore book? Is it some kind of group that isn't a licensee? Or is it someone that we took the time to vet? And to me, that's dispositive here. The advertisement is going to happen. Google is going to take the money. And so to me, the best thing we can do is fill that with folks who have been vetted, folks who are working with our operators. And as you pointed out, Madam Chair, so rightly, we are holding all operators accountable for what they do in their advertisements. To that point, I think that with the revenue sharing piece, I agree with Commissioner O'Brien 110%. And I believe that Caitlin said that the IEB feels very similar, which is there should be a heightened level of looking at these operators, and licensure is probably that level for those who engage in revenue sharing. And I would be very comfortable today making any decisions we make contingent on that. But I am comfortable with this moving forward because I do believe someone's going to fill the space. I think it should be folks that we are regulating and monitoring, and not folks who we're not regulating or monitoring.
All of these comments are so helpful, and I'll turn to our team. I guess I would reiterate that the idea of push and pull, that's critical to our very, very first meetings before sports wagering was legalized, Commissioner Hill, where you said, I'm brand new and I'm already seeing ads and feeling the intensity of sports betting advertisement on our national NFL games. And it's that push out, push out, push out. And so we were worried, to Commissioner O'Brien's point, on saturation, frequency, intensity. And that's what led us to this decision to adopt this reg as is, because on its face, we don't want people making money on on its face, right? Making money on wagering activity. Do we want them making money on every time they open an account? That seemed to be all consistent in terms of our values and our observations about frequency and intensity of advertising. When I learned about the comments that were coming in, I had to get my head wrapped around this because it still didn't make sense why anybody would want those arrangements. But it appears that these third-party affiliates, this is how marketing works. And it's the industry that I'm not familiar with. But we got a lot of information the other day on how this industry does work, and how by allowing them to have proper contracts in place, and even they would say the proper licensure in place, they can add a responsible gaming component that Breon confirmed for us, and compete with the offshore marketers. So that was a nuance I just didn't understand, and I believe, given the numbers of stakeholders that we heard from and how many were willing on an instant to come and talk to us, and on both sides, the operators and on the vendor side. So I look at our reg as the intention was right, and the intention continues to be right. But have we done something unintentionally that could actually have worse consequences? So I'm, so I understand it. We don't allow these types of arrangements, the third-party affiliates just won't necessarily participate. And so marketing will go more into that push space, which is that much more frequent in intensity. And the closed space will go to the offshore market. So the legitimate market, third-party marketers won't really have space to operate. And I think we saw Caesar's letter. That was, the first sign that it's going to impact their business. I did turn to New Jersey, and that directive is it's 2014. So it seems old, but when I had conversations with individuals who had written in, they directed me to this directory, the Director's Advisory Bulletin, because it really does create different licensure steps for different arrangements for revenue sharing or being paid compensation arrangements. So, so that's been working in New Jersey, and then we looked at around the country, and it made sense that we would borrow from Illinois. We didn't just borrow from Illinois; we went even further, and decided to prevent both revenue and CPA. And I think, again, the right intentions, but just an inadvertent consequence. I think Commissioner O'Brien, you've outlined, I think probably all the steps that all of us were taking into consideration. How can we, what can we do to protect the values that we thought about when we first adopted this? And now be responsive to what looks like some unforeseen consequences. And I would be ready to say that we make arrangements, and I'm very interested now to turn to the options, arrangements so that the registrant level could be used for those that are engaging in CPA or something like that, that's not involved in the wagering or the wagering activity, and then that higher licensure, and follow up with the research that Commissioner O'Brien is suggesting, because we should be watching this. This is, Commissioner O'Brien brought it to our attention at the beginning, something for us to look at. I think we probably didn't have, Commissioner Skinner pointed out, we don't have all the information now. It turns out we didn't have all the information then either. So, but we got a lot more now collectively. And I'm thinking that we could make adjustments. I'm not sure I'd want to do it. I think we need to give some degree of certainty and not make it temporary. But with that said, with information, we can always change our regs. But the only thing I was thinking, I think I heard somebody say maybe temporary or something like that. I think that these might be long-term contracts, and that's the only thing in the back of my mind is, what does that mean? Again, another inadvertent consequence. But I felt like the good news was that in many ways, everybody at that round table embraced the same values that we started with. And that was my big takeaway. They understood why we would have started with that, but they needed to explain to us why it just doesn't work in real life. So with that, perhaps we can hear the options that legal has come up with. And I see Kara is present and Heather is present. Kara, how are you doing?
Chair, I'm sorry to interrupt you. Can I have a follow-up?
Sure, yeah, and I was just going to ask Kara how she's doing. Sure, go right ahead.
So does it or should it make a difference to the underlying values here relative to profiting from gambling? If the profit is a result of the pull advertising versus the push advertising, right? I mean, this is a genuine question. I'm trying to understand, if that profit is generated by a patron who is seeking out, sports wagering as a result of a query that they have entered into the search engine. Why, I see a distinction if a patron is, go ahead, Madam Chair.
No, I don't want to interrupt you, but I think I can tell you what I'm thinking, then you can see if I'm even close. Because I thought about this. I think the push, as I understand it, this is that right now we're getting push advertising and it's going to everyone. It's not that, remember during our assessment of all the applications, how they explained how they tailored all their marketing, and they really worked on marketing to those who are interested. Now, let's be clear. There are those in the market who are interested in betting, and they're going to do safe and informed betting. Then we have those that we have to monitor them very carefully and make sure that they're not getting any kind of advertising, and that's where we do have those guardrails in place. They can't advertise to somebody on a BSE or it was underage. But otherwise, tailoring their marketing to the audience to that pull is, from my perspective, and I thought that's what Brianne, was saying, is that it's targeted, and that word not being a derogatory term, to those who are interested in sports betting, rather than the push, which right now goes out to all of us, including underage inadvertently, right? They turn on the TV and there's the push ad. So is that what you were kind of getting at, Commissioner Skinner, or is this something else?
Yeah, no, I'm just trying to, I'm just trying to just take us back to, you talked about the values that we attached to this initial, this, draft language, or it's not draft, the language that is appearing now in the regulation. If this is an industry standard, right, not just for sports wagering, as Commissioner Hill mentioned, but across all industries, and this is the way marketing works.
Yeah.
Why should we as a body take issue with that? Simply because we're in the, not simply, but just by the simple fact that we are regulating gaming here, right? I mean, again, if we can distinguish, if we can make a distinction between the kind of advertising, I think we should. And I think there's an opportunity to do that here in comparing the push advertising to the pull advertising, because again, with the primary distinction being there are individuals who are seeking out this information versus people who are inundated with advertisement that they don't want. It's the frequency, the annoyance factor, all of that. So I see two different buckets here, and that's why I think, for me, it would be helpful to understand, one, do the marketing affiliates that have these revenue share agreements with the operators, do they utilize the pull? I think they do. But do they utilize the pull advertising method or the push advertising method? That would be important for me to know. And then, back to my earlier question, are there marketing affiliates that would be at play here with our sports wagering operators who do utilize the push method of advertising?
I mean, you might be getting into the realm of the bigger, more established, more responsible players versus, maybe the not as ethical players who are in to do the churn and burn and to come in, make a profit, and leave. And to my take on why should we do this, advertising can help you get what you want. It can also push people and pull people to do things or buy things that maybe they shouldn't.
Yeah.
And so I think we're uniquely situated to be at the forefront of this. Again, I originally thought just don't allow it, and then the more I've become educated on it, the more I realize outright banning it is going to have the opposite effect of what we were hoping for by saying don't come. But I am equally convinced that simply saying go ahead and do it without any limitations is equally as poorly implemented, because that's not going to help us either. I do think that we have to be mindful about how we do this. And your question early on, Commissioner Skinner, about right now it's under a waiver. Right now there is sort of this manufactured timeline because of March 10th. So if the waiver addresses that March 10th, I would like to have a really detailed conversation about how do we change this in a way that is the most effective for continuing to do what we wanted, which is stop the saturation and protect the vulnerable in a way that allows the effective marketing to happen. So to your point, I've learned a tremendous amount over the last week, the last couple of days in particular. I would encourage you to reach out to Brianne. I know she's crazy busy, but she's also incredibly generous with her time, with your questions that I think some of us can't answer because we're not as knowledgeable about it. So I know that she was very, very praising of the people that were there on that roundtable with us, but I know there's also concerns about others in the industry and the practices and there are things to be taken from other jurisdictions and how they're doing this. So I would love to have a detailed conversation again about the idea, like Kansas has, of saying you can do this, but we're going to cap you so we're not inundated. Licensing, increasing the cost of the license to make sure you're committed. All of that, I would love to have a really detailed conversation about.
Yeah,
and maybe the short-term solution is the waiver to get past the 10th.
Can I ask one point of clarification on that? Do we actually impose a waiver? So was the waiver reg in place then, or did we do something like a suspension in this?
I think we suspended it.
So I just want to, I say that technical term because I wonder if it matters, and not because I necessarily care. So just keep that in mind. We suspended because I don't think our waiver rec was quite in place yet. Well, let's take a pause, commissioners, with our views and see what the our team has for options. And just let's check in with Kara and Heather. Kara, how is your work going?
We're working through a lot of applications right now, Madam Chair, to make sure that all of the people who have submitted applications, both for marketing affiliates and other vendors that will be necessary for the March 10th launch, are all set to go. So.
Okay, well, then, all of us know that you've been working around the clock, Karen, and leading a great team. So thank you. We'll turn to Heather and Kara for what IAB is thinking in terms of the elevated licensure topic that's come up in this connection with this.
Thanks, Chair. And I just want to thank all the commissioners. I think all these points are really helpful. We don't have a specific recommendation. We're certainly able to touch base about the different levels of investigations if the commissioners have questions, but we'll certainly defer to the commissioners' thoughts on the best way to proceed with respect to the current regulation that is.
Okay. Before I forget, Caitlin and team, Carrie, Todd, a lot of these comments also include some other comments on the advertising reg generally.
Yep.
I think we should probably set aside some time before the 23rd or 28th, Caitlin?
23rd.
23rd, right? To maybe address those two. So we might need a short or a meeting in the interim to just deal with the advertising reg so that we can really have some discussion on those outstanding comments. So Kara and Heather they're being team players and saying that they are waiting to get direction from us. What are some of the options that legal has come up with? What are?
Sure. And you're asking on the vendor side, yes?
Well, the combination, you've heard commissioners doubt, it sounds like we're probably not really all very far apart, but we all have some outstanding questions on how to make sure that our concerns would be fully addressed, or at least as addressed as we can do right now.
Mm-hmm. So in your packet, there's waiver language for the two different provisions, right? For the cost per acquisition and the revenue sharing. So the commission could choose to adopt both or one of those.
Can you bring that to the page?
That's your motion language. So it's not in the packet.
Oh,
I'm just saying that
motion. I don't really look at motion language on purpose. So I'm looking at options for, if you could just say them out loud.
Sure. So one option would be to waive the requirement or the prohibition in 256.013 on cost per acquisition relationships. A second option, you could do one or both of these, would be to waive the prohibition in 256.013 on revenue sharing relationships. And then I think there is to Commissioner O'Brien's point of wanting to bring in potentially other protections, there's a timing issue on that. And so the commission could decide to issue that waiver for a limited amount of time to get through launch, with the direction to legal to come back with proposed regulations related to these types of protections. That's another option. I mean, and a final option would just be to say, we're going to issue these waivers and we're going to put we'll direct you to sort of put those into effect on the 23rd when we come back. So a couple different options there.
Would you go over number one again, please?
Absolutely. It would be to put one or both of those waivers into effect for a limited amount of time. You could say through launch, through some period of time after launch, with a direction to legal and your team to come back with a regulation, be it in this reg or another reg, regarding protections related to cost per acquisition and or revenue sharing. What I mean by this, some of the things Commissioner O'Brien is talking about, would you like to limit the number of agreements? Would you like to have reporting requirements, that kind of thing. That's just going to take a little bit more time on our side to do the research, see what other states are doing, talk with Mark and all their interested entities.
Can
If you're looking
when-
for a,
Can you
if you're
tell me
looking
when
for-
the, just a second, if you could just tell me when the motion packet went out? I didn't know that that was going to be considered the option document. When did that go?
yesterday.
Yeah, sometime
It
yesterday.
came from Carrie yesterday. And I will say, you know,
5:08
the
PM.
motions in there are very straightforward. I think what I've just been saying is based on this conversation now, sort of what
Okay.
folks are thinking about.
And
Madam
just
Chair.
to be, yeah, just to be clear, we have, those draft motions are only guidelines for the commission, which is, they're so helpful. All right, let me just open that up. And I'm sorry, Jordan.
I was just
Commissioner
going to say
Mayor.
the draft from the team would put a date on there of April 14th. I didn't know if there was a reason April 14th. There was a thought.
I can jump in there if that's helpful. That's because that would be the date that whatever final version of the advertising reg you vote on the 23rd or 27th would go into effect on April 14th. So, you know, were you to change the reg for the final vote and adjust this language, that final version would go into effect on the 14th. So you would potentially not need the waiver after that date.
Thank you, Carrie.
Okay. So Commissioner Hill, you were starting to say something. I'm sorry.
I think your next question I thought was going to be, what is the temperature of how we should move forward? I jumped the gun.
No, taking the temperature again is, yeah, go right ahead, Commissioner Hill.
So I think what has been proposed by Caitlin is we do the waivers, time certain. She comes back, or the legal team comes back with some suggestions that have been put forward by Commissioner O'Brien. I have no issue with putting some restrictions on what I said earlier in my comments. That's how I think we should move forward at this point.
Other commissioners?
I agree. And if I understand the proposal, it's to waive the language that prohibits both revenue sharing agreements and CPA agreements through April 14th. And a deeper discussion around options for safeguards.
I think that's, I would say, Commissioner O'Brien, I know that we're attributing your guardrails to you, and I'm going to claim that there's plenty of guardrails that I think all of us want to have up. I would say that I haven't heard, I wouldn't necessarily adopt the recommendation that we just lift our reg altogether through April 14th. But I would say that my big takeaway, and I'm keeping it as simple and straightforward as possible, is that CPA is really important to the industry. And right now, I think our IAB and licensing department has been proceeding through a registrant process for all of the third-party affiliates that they think are not going to be participating in revenue sharing, but could be participating in CPA. So I would say CPA and the registrant level. And then I'd say if we were thinking about revenue sharing, given the input, that we would attach a higher level of licensure to those because of the issues that I think all of us are raising. Commissioner O'Brien articulated them, but I think at the very fundamental level, it's because we all care about the implications on RG. And so that seemed to me to be kind of a practical solution, at least to begin with, to make sure we have that additional guardrail of heightened licensure. I'm willing to absolutely entertain other guardrails. I did hear, I know that Commissioner O'Brien's mentioned cap. And we've heard that, kind of saw the reaction from the round table that they weren't thinking of any kind of a cap. So I guess I would want to know what we're going to have precisely, have legal look at before we come back. So whatever the list is, I think we should all agree on that today if possible. But my recommendation would be that two-tiered approach that seemed to be what our colleagues in Illinois did, and our colleagues, I believe, in Colorado have done, and what New Jersey seems to have done. Am I really off on this?
I think I can clarify procedurally how this would happen. So it's two different regs that we're dealing with. I think you could come to a consensus as a commission right now that that's what you wanted to do. If you, to the extent you allow for some amount of time, both of these types of agreements, you would then have the licensing structure, but it's dealt with in two different regs. So you'd issue
we've
the
got
waiver.
The two regs, but if can we do that today? That's all I need to know. I know we have the two regs and it's intersectionality, but can we address that issue?
I think what you could do is you could, if you so choose, you could vote on the waiver issue, or you could hold it until tomorrow. We have the conversation tomorrow, because I don't think we're going to get through the whole vendor conversation because there's more to the vendor.
I don't know, Caitlin. I don't know. Let's just see.
Well, you could hold the votes for tomorrow and do it together tomorrow.
Or we could do it today. So let's just talk about today. Could we?
So yeah, if I could, Madam Chair, if I could be heard also just on what I'm thinking too, before we start talking about timing of what you wanted.
No, I'm not talking about timing. I just wondered about the two regs. The two regs.
So
that's all I'm asking.
Just to be clear, so that you're taking the temperature so that I can be heard on that. I am of the mind of where Commissioner Hill and Commissioner Skinner are right now, which is this is a complex conversation. And I respectfully don't agree with the idea that the cost per acquisition is without risk. There is some element of push-pull in there, and I would like to know a little bit more about that. I feel like the people that are in the market right now, when we have this looming March 10th, which to me is creating this aura of, rush that I just don't think is necessary. And so
Commissioner O'Brien,
I just want to finish.
I'm trying to misunderstand.
I am of the mind of Commissioner Hill and Commissioner Skinner. I would like to do a very short waiver that then allows the team to come back with, how are we going to peel this back from a ban in a responsible way? So that's where I'm coming from.
So am I clear that right now what's being proposed is that we just lift a waiver of both CPA and revenue share and let the third-party affiliates enter into agreements now? Is that what we're saying? Is that because that's what will happen?
On CPA, that's what I would say on CPA in the very, very short term. Yes.
And I would add revenue share to that because I think there's still some outstanding questions that I have, and I don't know right now that an elevated level of licensure is going to do the trick. I mean, what else is there? What are the other options that we have available to us to keep track of those marketing affiliates? And then back to my fundamental question is, if this is the way the industry works, the marketing industry works, I don't know that I agree that we should be limiting that in any form. I still need to think about that.
The reason why I'm pressing a little bit is because with that green light, as I understand it, the third-party affiliates are going to be entering into these agreements. And so what we're saying is it's going to be through April 14th. That's really what, and supposedly Commissioner O'Brien's nodding her head at me. Yeah. And so
but we've already been told that DraftKings reached out to at least one of the affiliates when this regulation was promulgated because they understood that it was no longer allowed. And so I know it might be an inconvenience for operators to enter into these agreements only to cancel them out. But I just if we're talking about timing, I don't know that we have much choice. March 10th is launched. So, I don't think we have enough information to really make a sound decision today or tomorrow as to next steps relative to the higher level of licensure or any other safeguards that we might want to put in place.
Can I go back to Caitlin and not about today and the time and today and tomorrow? Mm-hmm. Can we, if we were to impose the higher, and I'm hearing I've got probably not a consensus, that's fine. If we were to impose a higher standard on revenue sharing, can we change the vendor reg today or tomorrow?
Yes.
To accomplish that?
Yes, you can change the
And
vendor.
so we could give a waiver on the reg on advertising with respect to both. We could add an additional guardrail that would require additional licensure on the revenue sharing.
Correct.
We could do that. Okay.
Yes.
Madam Chair, I just want to be respectful of our guests, attorney commoners.
No, I know.
They had a stop. So I just wanted to just make sure that he was okay.
Thank you for that. I'm terribly respectful of Paul and everybody else's time. I was just trying to get a little bit more out. Paul, do you need to escape?
Thank you, Madam Chair, Commissioner Skinner. First of all, I would never use that word. Second of all, Attorney Macarius had a hard stop at 3, but we were able to determine that I didn't need to be on that meeting. My hard stop is at 3:30.
Oh, okay. Well, Paul, do you have any additional insights on the legal options that have been presented to us that A&K hasn't voiced, because we haven't heard from you folks?
No, I think Attorney Monahan has done an excellent job with it. I'll say that what you have in your packet currently on the licensure reg, beginning at page 280, contains 2 kinds of proposed edits. Anything that is in track changes but not highlighted is what we were going to bring to you even before the advertising roundtable was scheduled. It requires third-party marketing and advertising affiliates to be registered. It tweaks the discipline reg, and I think there are 2 or 3 other tiny tweaks that we don't need to discuss. The material that is highlighted and in track changes in this revision is the language that we would add if there was going to be a waiver as to revenue sharing entities as well, and the commission determined that those entities needed to be licensed.
And that's at the very end of our packet, right?
I believe so. I'm not sure if it's the very last thing.
Page 382 is the highlighted revenue sharing section.
Yes, although there are.
Or 282, sorry.
Yeah, and there are a few words in other places. There's a line on page 280 and a line on page 281. Yeah. So if the commission is going to authorize CPA and registration, we are ready for that. If the commission is going to authorize revenue sharing entities subject to licensure, we are ready for that. And if the commission decides to go in any other direction, I'm sure we can work something up by tomorrow.
Okay, Commissioner Maynard. Thank you, Paul. Can you thank Nina for us? And if you need to leave, certainly leave. And again, yesterday you were also very, very helpful coordinating your calendar for us. So thank you.
I have to start with, I was smirking because Paul was very artful in saying that we can come up with some doozies around here sometimes. So I appreciate that. I would reiterate what I would say earlier. I mean, I've heard the push and pull be thrown around. My understanding is that most affiliate marketing can be categorized as pull marketing. That's a direct quote from our information. I do think there's a distinction. I actually think Commissioner Skinner made me think about something, which was, if we're not limiting how much money's going into the push advertisements, which is totally different, there is a customer cost per acquisition that I'm sure that they can look at how much they're spending and seeing how many customers are coming through the door, not in the same targeted way that we're talking about with revenue sharing agreements, but still, there is a fairness issue that I think Commissioner Skinner rightfully pulled out, which was, we are picking and choosing here a little bit. And to me, it's just different. If I go in and Google, and I did it a few weeks ago, right? Which bank has the best terms on this, right? And up pops the results, which I'm sure is affiliated marketing. I'm more comfortable with moving forward. I hear my colleagues saying that they're not, and I respect that, especially when it comes to the CPA model. Like, I am very comfortable with the CPA model. And then when we talk about the revenue sharing, I 100% agree. As Commissioner O'Brien articulated, I think we should have a heightened level of scrutiny on those operators around, and we should take time to come up and develop what that is and what it looks like. So I guess if you're taking my temperature, I would think the best course of action would be to go ahead and allow CPA agreements and just allow them outright, right? I'm just giving what I think it would be the best. And then give something temporary with the revenue sharing agreements with a quick turnaround on getting it done. That being said, I'm not going to stand in the way of doing something today to move this forward, because I believe there's a real risk in allowing non-operators into this marketing space. I would do the waiver if that's what it's going to take. So I'm happy to move forward on this today. That's my point.
Okay, I'm going to do a check-in on now time. Does somebody need to leave right now that's participating in this conversation? Because I wasn't sure at all in terms of scheduling. I'm going to tell you that I'm fascinated by today's discussion, and I'll tell you why. I feel like we're moving from the most conservative, and again, I started off with, where did we start with this? And it's all around our values and our desire to address responsible gaming and frequency and intensity of advertising, all of those issues that brought us to this regulation to begin with. And then I heard that we wanted guardrails. And we have, even from our folks who participate in our roundtable, including our RG specialists, advocating that at least allow for the CPA, because that will allow for acquisition and not push forms of compensation for marketing. But they recognize that revenue sharing might have a degree of risk that we might not have an appetite for, and that's where the higher level of licensure was proposed. But today what I'm hearing is that we want to allow for both without any guardrails for kind of the very important, most important time for advertising, which is at the launch. So I'm sort of struck by it. I would say that I'm not comfortable not having any kind of guardrails, and I stand by my side, but I guess I'm wondering why we think that this period of time is the right time to let I'll go with it, our guard down. Because I might just be missing something. I'm struck by the idea that we're doing it on a timeline of the reg itself versus a waiver where I think we've waived where it just wasn't practical. I guess I'm thinking too, wow, this is going to be an interesting impact on the industry because of their agreements and how they're going to get going. But I see Commissioner O'Brien, you had indicated that wouldn't be problematic for you and maybe not problematic for me. But I am surprised that we're going to let down all of our guardrails.
So I'll be candid with you, Madam Chair. My preferred route is we don't lift the ban until we have this figured out, and we go forward with altering the ban in a way that has the guardrails. I am probably the only commissioner that feels that way. And so that's why I'm saying that I can meet a middle ground with Commissioner Hill and Commissioner Skinner in terms of saying we have this self-imposed looming March 10th date. So we have to do, I'm perfectly fine if the decision today is we're going to continue to look at this stuff and we're leaving the ban in place unless and until. My only caution to that is it would seem to me, having been a little more educated on this, we might get a little more market saturation than we want. And so that's why I was saying, I'm okay with It's not my ideal, but I'm okay with the idea of the CPA going forward in the short term, because I think that will have the most positive effect on the launch time period and allowing us to expeditiously come up with these other guardrails to then say, all right, this is how we're going to license, limit, and allow these two forms of third-party marketing affiliates.
But what about revenue share, Commissioner O'Brien? Because I think Commissioner Hill and Commissioner Skinner were
Yeah.
saying lifting on revenue share as well.
So my concern with my comment on that is twofold. One, they said the vast majority of the third-party affiliates entering the market in the Commonwealth are not going to be doing revenue share. So
That's
to have
right.
a period of time where they can is not that troublesome to me. But I am also, if the majority of the commissioners on this body want the temporary situation to encompass both types, so we can come to a resolution on this and move forward, I'm not going to block it. I'd feel more comfortable with the CPA. I came out of that meeting feeling far more comfortable with CPA than revenue share.
Absolutely, absolutely. So that's really helpful because I was a little bit confused about that shifting. So that's really helpful.
Madam Chair.
Yes,
Madam Chair.
Commissioner.
I too was hoping that my comments was an olive branch, that a spirit of compromise, so that we could move forward with this. After hearing Commissioner O'Brien and her remarks, and they were very eloquent as usual, there are some issues that I want to learn about a little bit more because of those comments. And I thought by proposing what I proposed, that similar to what Caitlin had proposed, was in the spirit of compromise so that we could move forward. Because there is a little bit of difference of opinion here today, but I think we all want to get to the same place, but we're taking a different road to get.
The one thing I also, okay, go ahead, Commissioner Skinner.
I just want to say that I agree with Commissioner Hill, but in addition to that, I need to reevaluate, I guess, the principle, the underlying principle of, regulating this well-known practice of, payment for the revenue sharing arrangements. I mean, I just need to understand that a little bit more. And I did pose a couple of questions earlier that I'm hoping we can get answered relatively quickly.
Okay. The one we haven't focused too much. We alluded to it, but on the issue of the impact on small media and marketing affiliates and small operators. If we do no guardrails, that there's not any impact, so that's easy. But we want to keep in mind right now we may not have small operators. Should there ever be an opportunity for an online operator to come on, perhaps in a joint partnership with either an underrepresented owner, MBEs or WBEs, that down the road, whatever reg we come out with April 14th or whatever, but down the road, we always keep in mind what we learned, how these arrangements can impact the smaller businesses. So, and I'm cognizant of that as I think about the higher licensure. The reason why I think the higher licensure is attractive is because of what Commissioner O'Brien led with in terms of, well, you have less experienced marketing affiliates who may come in into the fray, who do have to rely on revenue sharing rather than cost for acquisition. So, and we learned of that. I'm not sure how to think about the April 14th deadline, and this is where I'll just ask for some more clarity. Caitlin, do you know, or Todd or Carrie, do you have any understanding of what these third-party agreements look like and their typical term? And have you learned anything about the business from that perspective?
No, I would say the April 14th is largely based on the advertising reg as it exists, and it would go out a month past launch. So,
right. So I understand where April 14th came, and I just wondered generally, have you learned anything about contractual relationships that the industry has?
No.
Uses. No. And so if we were to make it fact, we revisit, that's what we would be doing anyway, right? We revisit our regs at the finalization at any time.
Correct. That would be on the 23rd. So I think the idea of and then any changes from the 23rd don't go into effect until April 14th. So I think it's just the idea that nothing can really, whatever you decide would be in effect through the April 14th. And then after that, it can come back anew, right? Then it could come back as an amendment.
And is that, Caitlin, because we're in the regular process, so you don't want to have competing emergency regs with each other? Is that why?
Yeah, we can't do the competing emergencies. The Secretary of State will not be happy with us.
Yeah.
Does anyone know how many marketing affiliates we're talking about here? Because it seems, that we're saying now that there aren't that many, or at least there aren't that many revenue share marketing affiliates. But early on, when we first started talking about licensure of vendors, I think it was Director Lilios who was saying that there are hundreds and hundreds of these vendors potentially. So can anyone offer clarity there?
Kara can explain it.
So what we were getting in the beginning before the advertising regs were promulgated is very large lists of marketing affiliates. And we are talking multiple hundreds, closer to 1,000 when you're looking at all of the operators together. I think one of the things that's been a little bit of a push and pull, not to borrow from the advertising terms, is, looking at the different buckets of revenue share versus CPA and things like that. One of the other things that I just wanted to touch base on quickly too is in terms of when you're talking about guardrails, are you looking for further items under the reg, or would it be helpful to kind of go through, if we were to license the revenue share, there is a temporary licensure process for vendors that we could go through. Licensing can work with the operators to identify those. We would temporarily license them under the vendor regs. There would then be also subject to our normal process, which in terms of investigation, scoping, things of that nature, and it would go from there. Whereas if what I think I'm hearing is under the CPA, we would continue to leave it at the registration level, which is that, a lower level of investigation, things of that nature.
So is there a ballpark of the number of vendors we're talking about in this realm?
I'm sorry, I think I missed the beginning.
Under CPA and revenue share, is there an approximation of how many we're talking about?
Not the different buckets. No, I don't have that at this time.
If it's helpful, Commissioner, when we talked to Colorado, they said there were about 250 in the CPA and I think 7 in the rev share. So it was a pretty big difference. That was Colorado. So.
Karen, I thought you had indicated to me that you were starting to put aside those that wanted to engage in revenue sharing, and we're not concentrating on them for the registrant right now, pending our discussion today.
That's correct. So of all of the discussions that have been going forth, I think in terms of the discussions that licensing has had with the marketing affiliates, there was I don't want to say an assumption, but there are certain operators who thought that CPA was not barred under the reg. When the clarification came, we may have over pulled things in. We have put those aside. We are focusing on the CPAs and getting those registered.
And so the numbers, if you had to guess, you don't have any guess as to those that were indicating the revenue share?
So
was
we
it
have,
handful or was it 20 or?
we roughly have, I would say, about between 75 and 80 marketing affiliate applications that we're looking through, whether those are CPA or a flat fee, things like that. I would have to look into that more closely.
And so you haven't set aside any for the revenue share? I don't know why, maybe Loretta mentioned that or something, I'm sorry.
So I don't, if we have received any, they have been put aside. I don't have those numbers for you.
Okay, that's fine. So I do think Commissioner O'Brien mentioned, I think I heard 70% during our roundtable of the affiliates were represented at that roundtable. The sort of the marketing industry. Did somebody else pick up on that? I think that was my.
I did too. It was 70.
Yeah, and then that the majority do use the CPA approach for performance metrics and incentivizing, and then of course to compete with the offshore market. The revenue sharing again just feels a little bit different because it is betting. It is activity on. It is a conversation on activity of the bettor themselves. So do we need to think about this more? Or do we want to move on this today, commissioners?
I can make a motion in terms of what I would like to see, how I would like to see us move forward. Someone can second it or not. I move that in accordance with 205 CMR 202.023, the commission issue a waiver to all licensed sports wagering operators from 205 CMR 256.013 that allows cost per acquisition agreements and revenue sharing agreements until April 14th, 2023, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of General Laws, Chapter 23N.
Second.
I'm going to add my point of discussion. My preference would be to hold on this motion and not act on it until we find out if the impact on the industry by having maybe a one standard today and then April 15th, a new standard. And you can decide to entertain it, but I am concerned that we are going from one regulation that had really unforeseen consequences to now another one. I really don't know how to think about this kind of guidance that we're giving as a regulator, giving the industry, the operators. They're looking for consistency. Marketing is a big business. It may have no impact, and they're going to be probably thrilled to hear no guardrails. But I don't know the impact on the industry to say we're going to do something for April 14th, and then maybe April 15th institute new guardrails that will undo business arrangements.
I mean, my only question is what does the timing look like in order to get that information that you think is necessary before we take action?
Tomorrow.
Motion. Oh,
Tomorrow.
okay.
Oh, then why don't we table the motion until tomorrow at 1?
That's what I'm wondering.
Or I can withdraw it if that makes more sense.
Well, I am, and this is real time thinking, Commissioner Skinner, but I am a little uncomfortable not knowing if there's a practical implication. Again, today I feel like that's all I'm asking. My apologies. I hope again I'm wrong, like earlier when I asked about if there were a tech issue.
No,
um,
I agree with you, but I'm the reverse. I don't know if they're, I don't know, I fully understand the implications for outright prohibiting the revenue sharing agreements. So, I mean.
and I'm with you on that too.
Yeah.
I'm with you on that too. That's why the guardrail of the licensure kind of appeals to me, but I just don't know what it means in terms of how they would begin their. I know that they're looking for guidance from us this week because they're going to be engaging in these arrangements. So,
well, it could be that come tomorrow afternoon, maybe there are some discrete areas we all reach agreement on in terms of licensure treatment. That may make the next move over the next 4 to 6 weeks a little clearer for the 5 of us.
Yeah.
Right, and maybe some clarity to the industry.
Well, that's what I mean. If we decide that we are going to do, we could be in agreement, all 5 of us, on how we want to treat rev share, let's say, going forward, which then could potentially, give clarity going forward, even if there's a temporary waiver. It could make the vote a little easier in terms of, and a little more clarity by tomorrow afternoon.
So we can all sleep on a little bit, but I am loving, Executive Director Wells has found her icon today.
So I just want to loop in Kara. I'm just completely looking at this from a practical level and what the on the ops side. So if there's a vote tomorrow, that would give licensing clarity on what to do with these applications, because I am concerned we're running out of time before the launch date. And so if we have, hundreds of these vendors and they're all wanting to get licensed or registered, if we don't have enough time to do it by launch, that's potentially going to impact that process. So I just am hoping that what we figure out today or tomorrow just gives some definitive clarity to Kara and her team. And I know, Kara, is that articulating that correctly?
Yes, absolutely, and I appreciate that.
I withdraw.
So have any
motion,
registrants?
Madam Chair. I withdraw the motion so that we can further discuss.
Yeah, and maybe by tomorrow, Kara, if you guys, have there been any registrants already gone through the process?
Yeah.
Yes, okay.
Yeah, you've been doing it as the registrant level,
Right.
and that we did get clarity on because of exactly Executive Director Wells's point. But I think her point now is if we end up doing something different on the licensure level, they need that guidance, right?
Right.
Yeah.
Day before, right?
Yeah. All right. Well, I think this will give us a little chance to chew on this tonight. And Karen, I think I've got to ask you if maybe you can reach out to any of the operators for any insights on.
So, how would you phrase the exact data point that you're looking for?
Well, I'm a little jet lagged, Karen. So
yeah, I know. Okay, so let me ask somebody else.
Well, I wonder if the question really is, does a waiver of not even 45 days make a difference to someone's entrance into the market? Because the reality is, if people were only going to come in based on a CPA or a rev share, if they won't know for certain necessarily until April 14th, it could be they're simply going to wait to enter the market. I mean, we might be dealing with a much smaller number here.
So basically,
or the question for me is, if we decide to our decision really isn't certain, and it becomes, we only make it through April 14th. In light of how these compensation arrangements are made, does that throw their whole contractual arrangements off? Because are these one-year contracts, and they're going to, my hunch is that they would want to start their targeted marketing with launch. I mean, they're going to want to do that now. How would the lack of certainty or the temporary nature of our decision impact their business? Can they roll with it? If so, that's good to know. In between, I think we're going to try to get, additional guardrail ideas. I think we could impose those now and not have to wait until April 14th. I think we have some good ideas that Commissioner O'Brien and others outlined today. But really, for me, just understanding is this another possible mill, somehow impacting the industry inadvertently again. And I think, Commissioner Skinner, you're being sympathetic to the industry because you don't want to do that either, or empathetic, I should say.
Okay, so I can send an email or work with Bruce on the distribution list, but basically there's a waiver on the ban on CPA and revenue share until April 14th, and future discussion by the commission on that issue negatively impact your business operations. Is that the question? I'll make sure I phrase it right.
I think.
Yeah, I mean, at this point, none of them are allowed, right?
Lifting the ban altogether is great. They're going to say that that's.
But how about?
But the issue is
that there may be a short window. That's the question, right? Is a 6-week opening disruptive or helpful?
And then what if we decide to impose the guardrails afterwards? I think, now they're going to be up in a new licensure or not,
All right. So how about does an initial limited waiver of the ban on CPA and revenue sharing only until April 14th impact your business operations, particularly if there are added restrictions after the 14th?
Right, and business operations being their contractual or arrangements for compensation purposes of third-party affiliates.
Okay, all right, I'll tweak this and figure out how to send that out today or tomorrow.
Okay.
Or today, yeah, because you need it tomorrow.
Yes, please. We would like, for me, and if they're comfortable with it and they're great, that's going to be really helpful to me. I don't know. Anybody else have some questions from the operators? Commissioner Maynard, are you all set? Anything you want to add, or do you want to clarify that?
I mean, the question to me is, and it's been said different ways, but as simple as it can be, if we do a temporary measure, can you get up and running and do what you need to do and fill the space that you need to fill, knowing that we could add additional impediments in some ways and safeguards in others that could come your way. And if the answer to them is, yeah, we're happy to move forward, knowing that we may be on the market in 45 days, it makes the decision really easy.
Makes it easy, yeah. Commissioner O'Brien, anything you want to add? Is there any other?
No, I mean, I'm looking at it more like, at this point, they're not allowed, right? So my guess is, to use your word, Madam Chair, I would assume the advertising marketing online community is pretty nimble. They've done this in other states, so I can imagine that they said they've been laying the groundwork in Massachusetts in anticipation of the legislation being passed. So I don't know that our decision to get this right and to move quickly is going to be all that disruptive, but maybe this is one of the times I am unusually optimistic.
I think the biggest risk is, if those marketing affiliate agreements are not in place because they're prohibited by launch, what's that going to do to the search engines, right?
Well, they even said themselves, though, that takes ages, right? I mean,
okay.
That because Commissioner Skinner did that. I mean, Commissioner Maynard looked them up yesterday and he said, look, I'm looking at Connecticut and I'm still getting all the legit markets. And they said, well, it takes a while for the search engine to trail off. So I'm not worried about an imminent negative impact in that regard. Honestly, my concern is I want to make sure what we're doing and launching with minimizes saturation as much as possible.
Yeah.
I want us to try to nail that as well as we can.
My point is, if there were a consideration in terms of, negative impact to, not having this in place for launch, it would be that, which, again, they said, the marketing affiliates said that it would take time to kind of, have the
Yeah,
illegal sites sort of populated in these search engines.
Yeah, it would take a while for that to seep in, was my understanding. So I'm not really worried about, I didn't take out of that roundtable, there was an imminent crisis going to happen on the 9th.
Yeah. Okay. All right. I think I've got it. So I'll send it out. If the commission implements a temporary waiver on the ban on CPA and revenue share agreements until April 14th, while the commission determines a more permanent course of action, will that be disruptive or helpful to the business operations and contractual relationships with marketing affiliates?
Excellent.
We're good. Okay. I'll send that out today.
It's like a law school essay,
There we go.
business school essay. All right, that's really helpful. And thank you everyone for pausing for a minute. Plus, I think we can just digest this and think about anything that, Commissioner O'Brien led the conversation, but we all sort of have our instincts about what could be helpful to ensure that right balance for the business, but also for those, as I said, the values that drove us to this initial regulation to begin with. All right. Meeting went longer than intended, but I really appreciate it. Anything else? Okay, need a motion to adjourn.
Move to adjourn.
Well, we have are we not doing the annual report item on the agenda today?
Oh, gee. You know what, I'm sorry, because I printed my materials before I left. I knew that Krista was on. Thank you. Yes, Crystal, sorry to make you wait.
It's okay. I was just prepared to go tomorrow. I really think it'll take 3 minutes, but I have submitted to each of you a draft of a final draft, hopefully, of the FY 2022 annual report from the commission. So today we're just looking for your approval to finalize that report and release it officially.
Did everybody get a chance to look at
Or
it?
any comments if you haven't already sent me them.
Looks great, Crystal. Excellent, excellent, excellent job.
Thank you. Good to hear.
Any edits that anyone wants to make? Eileen? Are you leading it? Okay. Commissioner Hill, anyone? What?
I'm good.
Excellent job. Very well done.
And I have no further edits.
Thank you for.
That sounded ominous.
Commissioner Skinner was my final editor. Like, so nice to have extra eyes.
I'm ready to move, Madam Chair. If you're
Thank you so much. And to everyone who made a contribution to help. Thank you. Thanks, Krista.
I move that in accordance with 205 CMR, no, sorry. Backwards. I move that the commission approve the FY 22 annual report as included in the commissioner's packet and discussed here today and authorize its release.
Second.
Any further discussion? Excellent job, Crystal, and thank you for hanging in here today. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. 5-0. Excellent job and took care of some good business there. I think I have a motion to adjourn. I don't think it was seconded.
Second.
Thank you. Any further discussion or anything else I missed? And I thank everyone for their tolerating my little disruption. It was well worth it. So Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Thank you. And thank you, Karen. Thank you, Crystal. Thank you to the entire team, IEB. Thank you.